May I please, Lordship? Lordship, I beg to mention item number 3. Here I am for respondent.
Okay. What?
And Lordship, it may be kindly fixed on this month of 18.
Why not today?
Actually, Lordship, conducting council is out of station. He comes to
Item 3, said. Item number 3.
Yes,
Who's the conducting counsel?
he come to.
We inform the other side.
Yes.
Spread for by the learned counsel appearing on behalf of Mr. D. Come to. Please cancel the order. Mr. D. Kamduk, learned counsel for the respondent, is said to have some personal difficulties. And on a prayer made on his behalf and not objected to by the other side. Is this man? We'll have it in the week commencing from 22nd, not on 18th. Okay. On 23rd.
Okay, Lordship.
Very
Give your
good.
best.
Lordship, yeah, here is a one WA of 24/20/25 service matter. This matter may kindly be listed on 11 this Thursday. There is an urgency because this matter is challenging the order copy of the Justice Conduct Act, and this are supposed to be listed on the 22 September.
That will be for what? For orders? For hearing?
Here, and here is one more. The one more is there. WA number 16 AP of 2025. It's a rising out of the this payment of the system. This also made this from Sam.
Yes.
I beg to mention item 8. This is Lordship for condemnation of delay. I am for respondent 1, but my name has not been reflected here, so somehow it got missed. So therefore, if it can be taken up next week, Lordship, it will be for consideration of that IA application.
That's what we have to say.
Mr. Perme, I have taken his consent.
It will be for respondent number
1.
1.
It may be, my name may also be reflected. It's not reflected here.
Yes. And again, learned counsel for respondent number 1. Submit that. Since her name has not been reflected in the cost list, she's not prepared. And place that matter listed again after a week. Is this matter again after on a table? The name of Mr. Daniel, counsel.
Right.
Yes.
I beg to mention item number 9 minutes.
Yeah.
Item number 9 will be appeared by the leading counsel, Your Honor, within air. So this matter may be leased on 12, Your Honor.
It'll be for the appellant.
Yes, I'm for the appellant. Their name is not in the course list, but their name is in the Wakalat Nama.
What is your name?
My name is Tamirin.
Amirani, learned counsel for the applicant stroke appellant submits that she's led by Mr. P.D. Nair, learned counsel. The matter, and since yes, some person will needs to appear before the court today, it plays that the matter is said on 11.
Well,
Well,
yes,
Friday.
on Friday.
Have it on 11. Why do you want on 12th?
His other matter also, so he coming on Friday.
No, see, you cannot always depend on this convenience. He has also accordingly done to adjust. I'm told that Tuesdays and Thursdays are hearing the PPA exam. can bench these.
That's the energy.
It's only the.
Item number 1.
Your Lordship. There is a order from this Honorable Court 09/04/2025, Lordship. We are supposed to file one IA for condonation of delay. Lordship, this criminal appeal is a jail appeal, Lordship.
Where is the application?
Lordship, in fact, I have been to Teju jail, Lordship. I have taken the signature also, Lordship. I have filed the IA also. I don't know why registry has not listed the IA.
When did you file?
Lordship, it's been almost 1 month, Lordship, I have filed.
There's an office note, 8 of September, saying that the learned legal aid council has not yet filed application for condonation of delay.
Lordship, I have filed. I don't know why it is not listed.
Is right, although the office note dated 8/9/2025 indicates that condonation of delay application has not been filed by the learned legal aid council. Mr.
JJ, Lordship.
JJ,
Legal Aid Council. JJ.
learned legal aid council submits that he has already filed the same with month back.
Lordship, that's
Take it up with registry to verify, and
actually, Lordship, the registry had some, I don't know, they had some difficulties in listing that matter, Lordship. They had some technical issues.
what is that?
That was not properly advised to me.
Registry verify, and if there's some corrections, rectifications to be done, public rectification.
I have not received copy of IA.
You're the BP?
Yes, additional BP.
The same be intimated to the learned legal aid council. The learned legal aid council can also supply a copy of the application to Mr. G. Tadov, learned public prosecutor. List again after a week on a day to be
Week, Lordship, of the review.
apply here.
Okay.
Item number 2.
Yes.
Support time.
How much time?
4 weeks.
What did you say?
You want to-
Government pay?
Yes.
There is for further 3 weeks time to apply government pay.
Item number 4 and 5.
You can see that fine. Against order page 376. What is this IA? IA means subsequently the respondent filed this IA saying that respondent filed an IA for vacating the interim order. I see. Considered the occasion. They filed the IA basically on the ground. They want to say there was a proprietor is there of the appellant, as well as there is a power of attorney holder. So far as the proceedings concerned before the single judge matter, the power of attorney holder contested the matter. While filing the appeal was filed by the proprietor. Now they have filed subsequent an application. The proprietor has shown some affidavit of 1-page affidavit, so-called affidavit, where he saying that I have not signed the Wakalatnama. Then we have
hearing the admission on there. And the learned
Yes.
revision bench has kept the mobile upon open.
yes.
That's your lordship can
Yes.
hear the admission.
Yes. So the appeal may be heard on merit.
Yes. Maintainability point has been kept open.
That
Every time of hearing the appeal.
lots. The issue is here very simple, my lord. On 5th of
July 2024, a tender notice inviting tender was issued, which your lordship will find at page 59. The issue is in a very small campus, page 59. Yes.
Yes.
The executive engineer, so Chang on behalf of the government of Arunachal Pradesh invites the item rate bids in electronic tendering system for construction of roads under Vibrant Village Program (VVP) for each of the following works, including their maintenance for 5 years from the eligibility and approved contractors registered in appropriate class with CPWD, PWD, etc. Now there is a table, my lord. The table will find name of the work, the third column, my lord. 1027 L027 road from Prema Pau to Rao and other particulars are given. Now, pursuant to this notice inviting tender manner, the applicant as well as the private respondent here filed tender. Now, in the technical bid, the tender submitted by the respondent hearing was the repetition before the signature. His bid was rejected as being found non-responsive. Then evaluation blocks will find at page 140.
You are the writ petitioner.
No, they are the writ petitioner.
Or you are the
I am the respondent to whom the work order was issued.
private respondent in the
In the writ petition. Fine. Page 143 is the evaluation of the
work order has been issued in your favor.
yes, ma'am. And there was no interim order. I continued with the work. Writ petition was allowed. Therefore, I preferred an appeal. In between, there was a gap of 3 days. Then there was a stay by the South 14th Division bench, based on which I am continuing with work. Before the signature, there was no stay. I was working. The execution was continuing, and writ petition was allowed. Thereafter, I prepared an appeal. In between, there was a gap of 3 days. Again, stay was granted by this on the division bench, based on which I am continuing. Page 143 is the matter the evaluation by the committee. Page 143. Now, page 143 starts on the top. You'll also find page evaluation report part 1. That is technical bid matter. Then next page, you also will find page 144. There's a table. In the table, my lord, name of the bidders is given. Serial number 2 is the name of the farm of appellant farm. Tenzing Construction. Table, my lord, photo. And serial number 3 is the respondent writ petition. NT agency, non-responsive. Now, because remarks one isn't given the reasons, attracts clause 4.4b(b)(1), 4.4b, then small b, Roman 2, and 4.7, Roman 1.
Number 4. Number 4 is the
Number
writ
4
petitioner.
is the writ petition.
And number 2 is the appellant.
Appellant. Respondent number 5 is the writ petition. Now, for these grounds on which the bid submitted by the writ petitioner respondent is found to be non-responsive in the technical bid itself, you also will find from page 64 onwards. Turn back page 60. These clauses are at page 64. They did not meet the requirement of these clauses. These clauses have been clear. Page 64, my lord. 4.4BA, then small b. Each bidder must demonstrate purchase for man. 1. Availability for construction work, either owned or on lease or on hire, of the key equipment stated in Appendix to ITB, including equipments required for establishing field laboratory to perform mandatory tests and those stated in the Appendix to ITB. Now, next page, you also kindly turn to see what is the next. It is 4.4BA. B Roman 2. Availability for construction work of technical personnel as stated in the appendix IT. And the last one, what we find the last reason was page 66. On 3 grounds, my lord, their technical bid was rejected. 2 grounds I have shown. The third one is at page 66. That is 4.7 Roman 1. Page 66, my lord. 4.7. Even though the bidders meet the above qualifying criteria, they are subject to be disqualified if they have one, made misleading or false representations in the form, statements, affidavits, and attachments submitted in proof of the qualification requirements, etc. These are the 3 reasons. Now, Lordship will find in page 64 when the requirement of submitting, demonstrating availability of for construction of these materials and personnel, your Lordship will find in the ITP page 70, at page 17.
Yes, what is there? It's on the
Page 17, my lord, at the just above the table, you will find 4.4b, the key equipments for road works and field testing laboratory are. These are the name of the equipments which the bidder must possess in order to execute the work. Truck mounted water tanker, tandem vibratory roller, pneumatic tire roller, bituminous hoe, single drum soil compactor. These are the equipments and machineries. And page 8.
These equipments are not
Not-
available with the petitioner.
I'll come to that. So this is the first requirement which they did not fulfill according to the report of the tender bid.
4.4B is also not fulfilled.
Yes. Well, I have shown at page 66 that the reasons given are one is 4.4B. 1 speaks about availability of construction work, either owned or on lease, hire or key equipment. So they did not possess the key equipment necessary for executing the work. And second is, my lord, technical personnel, which your lordship has seen at page 65. Equipment and personnel. Out of 3 reasons, 2 reasons were that you did not possess required equipment and machinery and technical personnel at page 65. And which, according to the standard document, are mentioned in the ITB. And ITB at page 78 shows that the machineries and equipments necessary. And page 79, sorry, page 81 is, my lord, technical person.
81.
81. 4.4 B, capital B, small b, then Roman 2. At page 81, what we find, number of technical personnel, qualifications and experience will be as follows. Now, the bidder has to show that for site, as a site engineer, the person has to be there who is holding the qualification of BE civil engineering, then assistant site in charge, diploma in civil engineering. So this way the whole list is given. So these conditions in the tender were not fulfilled by the bidder and petitioner. That is why it was rejected as reflected in the evaluation process seen by. And third was whether there was any pending litigation. That also they did not disclose. They had pending litigation. They did not. So these are the 3 reasons. Now, while the tender, their bid was rejected, they filed it, and in the judgment filed by the single judge will find, start from page 376, how the matter was dealt with. Start from 376. Then you also kindly turn to the relevant paragraph, that is paragraph 14 at page 387. Page 387, Lordship, kindly just have a look at once, paragraph 13 also. The Lord Standing Council has submitted that the construction of the road in question is in the border areas and immense public interest is involved. He has also submitted that the execution of the work is going on smoothly and at this stage any interference will not be in the interest of the states. He has also submitted that by this time the e-portal perhaps has been closed and therefore it is not possible to have a financial evaluation even if the petition is successful in the request. Now, next paragraph 14, what is the contention we have read? Supporting the contention of the department's issuance of answer, who has appeared on line for the respondent number 5, has submitted that admittedly in the NIT in question, there were 3 packages and the petitioner had submitted bids for all the 3 packages. It is submitted that the requirement of having a list of machineries and list of technical personnel as per the clauses mentioned above is to ensure that the work in question can be completed within the time stipulated without any compromise with the quality. He has submitted that when the same lists were submitted by the petitioner for machineries and personnel, if more than one work was allotted to him, it would not have been possible to give the use of machineries or technical personnel in the different sites of works, whereby there would not be only be delay in execution of work, but also affect the quality. Same. He has also submitted that it was for the petitioner to make an understanding that in that case he is granted any work. In case he is granted any work, he forego the other works. He has submitted that practically it is not possible to undertake and complete the work with the same equipment and personnel in more than one site if more than one work is allocated to the petitioner.
Okay, what does it mean? That
It means, my lord,
no,
there were 3 packages.
petitioner has more than one work.
No, ma'am. Petitioner has submitted bid for 3 packages. And for all the 3 packages, he has submitted a list of technical personnel and equipment, one set. Now, if he is granted work in all the 3 packages with one set of equipment and with one set of technical, he cannot execute the work. And that is the first reason on which it was rejected. See,
Otherwise, we are concerned with one package.
we are concerned with one package. In this case,
In this case, we're concerned with one package, but you say that the petitioner had responded to 3 bids,
yes,
3 packages
with one set of
with one set of the what do you call it?
equipment and machinery and technical personnel.
And if he gets all the 3 tenders,
You won't be able to execute.
how will he divide?
First of
This is what you submit.
First of all, there is a complete non-compliance with the requirement of tender condition, which says that you must for one particular package, you must have this person. It doesn't anywhere say that for all the 3 packages, one set of equipment and one set of technical person will take lead. NIT doesn't say so.
As of today, what has happened to the other package?
Protects.
Any information?
I left you. But that was first reason on which it was rejected. You can see you have submitted for 3 packages, you have submitted B, and all the 3 were considered on the same day. And it was found that for all the 3 packages, you have given only one set of equipment and one set of techniques. That was reason number 1. And second was, my lord, the suppression. He had pending litigations and that he has admittedly suppressed. He has the petitions pending. With petitions, yes. With it.
How many?
1 or 2? One.
It's the same respondents,
Government.
government of state.
Yes. So now the finding of find at page 391. Page 391 to find. Paragraph 3. As per the first clause, there is a requirement to give a list of the equipments and machineries, and as per the second clause, the list of technical personnel is given. The imperial order doesn't specify or cite any details of invocation about the aforesaid clauses, and in the affidavit, it has been stated by the department that in the list of machineries, certain invoices of machineries were enclosed, which has been stated to be not genuine. Apart from the fact that aforesaid allegation has been denied by the petitioner, has found that the said reason has not been disclosed in the rejection order dated 2024, and clearly appears to be an elaboration made in the affidavit by the department. So, my lord, the finding of the honorable single judge is that although those clauses were mentioned, and although in course of the writ proceeding before the honorable single judge, based on the affidavit's findings, it has been clear that it is an admitted fact that there were NIT was for 3 packages, and for all the 3 packages, one set of equipment, one set of technical person was submitted by the writ petition. Now the honorable single judge, with all respect, I'll submit, says that you have not clarified, but it has become absolutely clear. Petitioner could not say, my lord, writ petitioner could not say, no, for 3 different works, I have given 3 different set of equipment and 3 different set of technical.
Okay, what is this? The impugn order does not specify. Which is that impugn order?
And impugn order will find that I have just now shown my lord. Tender evaluation. And its evaluation of 2/8/2024 at page 143 and 140.
Which one? With evaluation report?
My lord,
143.
144. The doctor does not see my
144.
yes. His technical bid was found to be non-responsive on 3 counts.
The impugn order does not specify or cite any details of invocation of 2 clauses. 2 clauses means?
One which I have shown my page 65-66. Clauses are mentioned at 144, 6/66. And in the evaluation report, those clauses are mentioned. And in fact, my lord, the writ petitioner submitted one set of documents for all the 3 packages. Not a case, but it is in the paragraph 22, when reliance was placed in order to, my lord, support this finding on that Gordon Das case. That is a case where, my lord, no reason is disclosed in the document under challenge or the order under challenge. And subsequently, by filing an affidavit, if you elaborate and come up with some cause that will not be taken into consideration for the purpose of holding that the document in order is valid. That is the, you are aware of that, Gordon Das case, page 1.
So how do you explain this 144 then? It says not responsive.
Well, 144.
And you're trying to point out the remarks also.
Well,
not responsive, but it's because of this.
Yes. Now, page 144, the authority has given the clauses under which their tender was found to be technically not responsive.
Correct. Attracts clause 4.4b.
Yes. And if your lordship goes to the relevant clauses, it is clear that it requires you to submit documents to show that you have got equipment, you have got technical person. Those things there.
Equipment, technical persons.
Yes.
So lack of
non-fulfillment of the conditions of tender.
So this, according to the learned single judge, was that
further elaboration was necessary. That see you.
There's no elaboration.
Yes. And in my humble submission, when the clause is very clearly given,
and they have made the elaboration in the affidavit instead.
Yes. Now the finding of the honorable single judge is elaboration was in the affidavit, but this page 70, it is absolutely clear that tender condition requires that you must have. It says key equipments for road works and field testing laboratory are these, and if there is a reason in the document in order whereby the technical bid was rejected, that this is the reason. That means you don't have it. You show that you have, and you have not been able to show that you have got 3 sets of equipment and 3 sets of technical personnel. So in that view of the matter, my lord, my humble submission before lordship is that this finding at page 391, paragraph 21, is not possibly valid so far as the facts of these cases are. In a fact situation where nothing is disclosed in the impugn order, but subsequently by filing an affidavit, you prove your case and try to give reasons to justify your impugn order, then in those cases, when relying on that Gordon Das case of the AIR 16, has been relied on it. That would be a good case for holding the in order to be bad on the ground that reasons were not disclosed in order, but subsequently by filing an affidavit, you are trying to justify it. This is not the case here. Justification is there in the impugn order itself. It clearly says that there is non-compliance of these clauses, And this process requires you to keep the list of equipments and machineries and list of technical person. And lastly, you have to disclose about the pendency of any litigation, which also they have indicated that there was one litigation pending, which we have submitted. So far as that part is concerned, my lord, what we find, this court has found there was one litigation pending, even of the my lord, present appellant also, but their appellant was a respondent in court. He did not find it. But the finding is that so that also has to be taken to be a litigation pending between the parties, and you have also submitted.
With the patient. Has it been mentioned in this
Yes.
judgment?
Yes.
Under challenge?
Yes. Para 24 at 393. Para 24 at 393. What remains to be examined is the invocation of clause 4.7.171, which pertains to making misleading statement or misrepresentation or having a record of poor performance. Apparently, the same power is discretionary in nature, and it is settled position of law that whenever discretion is applied, the same has to be done by following the due process and with due care in individual. The department is trying to justify invocation of same clause by citing that the petitioner had not disclosed pendency of litigation in the High Court. The response of the petitioner is that even the respondent number 5 had a litigation pending in the High Court which has not been disclosed. The explanation by the learned counsel for the respondent number 5 as well as the department is that in the same litigation state, respondent number 5 was in a position of a respondent and therefore there was no requirement for such disclosure. Therefore, such explanation cannot be countenanced in view of the fact that the requirement is for disclosure of pending litigation without any further clarification whether party was a petitioner or a respondent. So on this ground, this was held.
So what you maintained is that since you were a respondent, there was no requirement to divulge that there's a pending litigation.
Right. But I did not start. Somebody files a case against me. I am not responsible for that ground.
Oh, it's only when you file your case.
Right.
When you file a case,
Right.
then it can be taken as a litigation and you got to disclose it. If somebody files against you, that's not a litigation
Okay.
in terms of the requirement under this NIT.
That was.
But where is that clause, the NIT?
I
Disclose your,
yes. Well, that your lordship will find in the page. Find it page 66. Find 171.
stating of false representation.
Yeah. Yes. But there is another clause which says that
No,
any pending litigation will be disclosed.
not litigation specific.
Well,
Is there a requirement, to declare that there is no pending litigation?
There is a
There's a requirement.
Yeah.
Then this clause also will be attracted then.
Fine.
Both sides.
Information regarding any litigation or arbitration during the last 5 years. It's sufficient that I would like to make your notes is that in respect of the finding at page 391, paragraph 21, where the signature says that relying on that Gordon the state that there was no elaboration. Madam, if 52 Supreme Court doesn't say about elaboration, in different premise manner, it says that any order passed by the authority in discharge of its public duty, the validity of the same has to be found from the document itself and not from the explanation given in the affidavit, which your lords will find at page 21. I'll just read that paragraph. Page 39, 392, my lord, are the 2 paragraphs of that Gordon Das case, because subsequently relied on the Mahinder Singh Gill case also, my lord, then on Article 329B that was 392 that Mahinder Singh Gill judgment. There also it was relied.
Where is it?
Page 391 of the reliance was placed on Mahinder Singh Gill, where there was a reference of Gordon Das case of previous. But it says, my lord, the second equally relevant matter is that when a statutory functionary, this is the, my lord, proposition, when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise. Otherwise, an order bad in the beginning may, by the time it comes to court on account of a challenge, get validated by additional grounds. Lords will kindly note the word additional grounds later brought out. We may here draw attention to the observation of Post J in Gordon Das Bhanji. Public orders publicly made in exercise of statutory authority cannot be construed in the light of the explanation subsequently given by officer making the order, what he meant or what was in his mind or what he intended to do. Public orders made by the public authorities are meant to have public effect and are intended to affect the actings and conduct of those whom they are addressed and must be construed objectively with reference to the language used in the order itself. In this case, possibly, my lord, I respectfully submit, this proposition of law is not at all attracted. The authority did not come up in the affidavit to give any fresh ground or additional ground to support the impugned order. It is there in the impugned order very clear the 3 clauses under which the technical bid of the petitioner was rejected. And if your lordship goes to the ITB, which I have just now shown, my lord, and also the tender condition, it's very clear that the requirement under the tender is that you must have technical person which are specified, engineer, etc., and the technical equipment and machineries which you are required to have in order to execute the work. Nowhere in the tender condition says it is there that see with one set of technical person and with one set of machineries, you can execute the work in 10 different places. My lord, lordship will kindly visualize one thing. Even practically thinking, if a person gets 3 different packages in 3 different districts with same set of equipment and same set of person, can he execute the work, my lord? Will it amount to fulfillment of the tender condition? Now you have got 10 machineries, 10 my lord, excavator. You have put all the excavators in Itanagar. You have got another work in support in a different giant Tajam. So long as this machinery is used here, it cannot be used there because you have got to one set. If you are required to have 10 excavators, all 10 are here. That is why, my lord, I say, my lord, it is not a, the government also has taken a stand based on their tender condition. You ought to be aware, my lord, there are plethora of judgment which says the authority, the employer is the best judge to say what is the meaning of the tender condition. I put one technical issue. They are the best judge. They have thought that for the three different packages, and all the three packages were opened on the same day. They have taken a clear stand in the affidavit say that you have for three packages, you have given one set of documents, and that is why your technical bill was rejected. And right, so now the Honorable Single Judge says that no, you have not elaborated, and it is and supported this findings with the judgment of the Gordon Das and Mohinder Singh case. Those are in a different context where no ground is given, no justification given in the appeal order, but subsequently by filing an affidavit, you are giving additional grounds to justify. You are giving grounds for the first time, fresh grounds. Here it is not a fresh ground, not a question of not disclosing anything in the appeal order. Appeal order is absolutely clear. Evaluation by the technical committee matter is absolutely clear that these are the three grounds on which your technical bill is rejected. And last matter, what is the operative part? What should we kindly see? What? Yes. Madam, may kindly turn to page 394, the operative part. Para 28 at the bottom. In view of the aforesaid facts and circumstances and the discussions made above, left with no other option but to interfere. The implement order dated 28/10/24 by which the technical leader was rejected. Consequently, all the consequential action, including the issue of the letter of intent and the work order in favor of the respondent of files, then interfered with NR accordingly set aside. The remaining part of the work will be accessed and the same is required to be allocated to L1 bidder, which is found eligible in accordance with law. However, we clear that so far as the works done by the respondent of 5 in the meantime is concerned, there will be no restrictions toward payment and release of the bill to the respondent of 5. And in this case, there is one hidden factor is there. Before filing the present writ petition, the writ petitioner filed earlier writ petition challenging the same, and then they withdrew subsequently and then filed a fresh writ petition. So in the meantime, I continued with the work. Now, my lord, when there was no interim order in the before the honorable single judge also, the appellate lordship continued with the work, and in between there was a gap of only 3 days when the writ petition was allowed and the authority was there to proceed. After that, my lord, there was an interim order in this case where a stay was granted and we were allowed to continue.
Okay, what is the percentage of work already completed?
Now it will be around, last time I reported submitted giving about 70%.
70%.
Yes, it was.
There was no interim order in the writ petition, you continued.
Yes,
Then after the writ petition was disposed of, while the appeal, there was a stay.
yes. And then
Again, you
I'm
continue.
continuing. Even now I'm continuing. My government, government will say about the
My lord, at this stage, formation cutting, drainage, GSV, all drain culverts, or complete only BT,
bitumen.
bitumen is left. So now bill for that work which has been already executed also submitted for payment. So it is it's
And they will also say that there were 3 packages for which tender was floated, and the writ petitioner submitted tender for all the 3 packages, which one set of government and one set of.
No, that you said.
No.
But my question also was whether the other two remaining packages,
Yes.
what has happened to them? Has it been allotted to them?
all 3 packages his bid was rejected.
Rejected.
Yes. Now there one of their ground is also subsequently when one of the he participated in 4 packages. 3 packages open in same day. That 3 packages were rejected. And in the amount of this bid was rejected on August. Then on October, one more bid was open. Then there his bid was accepted. So they have taken ground of same set of document. You have rejected other 3 and you have accepted this one. That is after 2 months.
That is in respect of one package. Yes. Yes,
No, definitely.
yes, yes.
Mr. Das will definitely hear you. Will definitely hear you. I just had some query to find out from the government. So that's what. I don't think Mr. Mazumdar has completed.
My lord. Then
Yeah.
I'm
Something left.
yes, ma'am. We did.
Okay.
I'll
Let
be-
him,
I'll
let
be
him come.
relying on two judgments. Sir, basically, this is my submission. My submission is the authority did not commit any error in rejecting the tender on the ground of compliance with the requirement of the tender condition. It says that for a package, you have to submit a tender along with documents to show that you can demonstrate that you have either on hire or lease these list of equipments and machineries and these key engineers, technical person, which you have paid. And as you have also seen subsequently, when in the second phase, for one package, a tender was floated, as my learned friend has stated. There he filed his, submitted his tender and he got a work order. So he is using technical personnel and machineries for that. So this is my submission basically. My submission is basically that the finding in paragraph 21 by the Honorable Single Judge is absolutely erroneous in the sense that the judgment relied on of 1952 Supreme Court Gordon Das and subsequent 79 they were of that in states. Here are completely in different contexts where in the impending order no reasons are given and by a subsequent affidavit filed by the department reasons are given, additional materials are placed to justify the impending order. But here is a case where it was already there. We go by the reasons given in the report of the tender evaluation committee and the tender conditions where it says that under these clauses you have to demonstrate that you have got technical person. And as far as separation is concerned, there was admittedly a separation of one. And when I'll be applying just two judgments.
Yes, what are they?
Yes. One is my lord 2023 SCC online, page 671. Tata Motors Limited versus Rehan Mumbai Electricity Supply, 2023 SCC online 671. Para 52 and 53. Para 50. Ordinarily, a writ court should refrain itself from imposing its decision over the decision of the employer as to whether or not to accept the bid of a technical tenderer unless
So
something
just a minute. You're reading from
para 52 man.
says in Ronak International out here. 2023.
SCC online, page 671. But Ronak International.
No, this is 2023-19, volume 19 SEC. Tata Motors versus.
Tata Motor versus Rehan Mumbai Electric.
That's correct. But 52 is something else. Ronak International. You're reading from SEC or what?
I'm reading from yes, SCC online. But I have supplied a copy.
It's not tallying. That's the thing. The paragraph's not tallying.
Yes, but I'm reading from SCC online. What is only SCC online?
Yeah.
Yes.
Online.
Para 52.
Yes. It starts in Ronak International. What is that sentence? How does it start?
Ordinarily, but it will be thereafter. It will be thereafter next week.
It's 55.
Thereafter, I'm not getting somehow. Ordinarily, a writ court should refrain itself from imposing its decision over the decision of the employer whether or not to accept the bid.
Yes, yes.
We accept the bid of a tenderer unless something very gross or culpable is pointed out. The court ordinarily should not interfere in matters relating to tender or contract. To set at naught the entire tender process at the stage when the contract is well underway, this is an important matter. Would not be in public interest. Initiating a fresh tender process at this stage may consume not of time and also loss to the public exchequer to the tune of crores of rupees. The financial burden implications of the public exchequer that the state may have to meet with it if the court directs issue of a fresh tender notice should be one of the guiding factors that the court keep in mind. This is evident from a three-judge bench of suspension. Then para 53, I will not read the both one. Bottom 3-4 lines, right hand side was defined even when, even when, line about 1, line about, next paragraph is line about 10,
Even when.
even when,
It's para 56 here.
even when some defect is found in the decision-making process, the court must exercise discretionary powers under Article 26 with great caution and should exercise it only in furtherance of public interest and not merely on the making out of a legal point. The court should always keep the larger public interest in mind in order to decide whether its intervention is called for or not. Only when it comes to a conclusion that overwhelming public interest requires interference, the court should intervene. Next matter is 2020 following 16 SCC. Silpi construction and your lordship is aware. 2020 following 16 SCC 489. Here I'm relying para 19 and 20. Here it is same for maybe there.
So how does it start with your copy?
Well, the essence of the law laid down in the judgments.
That is para 20 here.
Cancel.
Essence of the law laid down in the judgment
Yes.
referred to above.
Yes, ma'am. Essence of the law laid down in the judgments referred to above is the exercise of restraint and caution. The need for overwhelming public interest to justify judicial intervention in matters of contract involving the state instrumentalities. The court should give way to the opinion of the experts unless the decision is totally arbitrary or unreasonable. The court doesn't sit like a court of appeal over the appropriate authority. The court must realize that the authority floating the tender is the best judge of its requirements and therefore the court's interference should be minimal. The authority which floats the contract or tender and has authored the tender documents is the best judge as to how the documents have to be interpreted. If two interpretations are possible, then the interpretation of the authority must be accepted. The court only interfere to prevent arbitrariness, irrationality, bias, malafide, or imperversity. With this approach in mind, we shall deal with it. The third one, the Drawn of International 1999 1 CP 09.
So you line only one paragraph.
Matter. Then lastly, matter 99 1 SCC page 490. Here, possibly, there's not a difficulty, although page numbers may not tally. This judgment I am relying.
This is what Ronak International.
Madam.
Paragraph?
Paragraph 8 and 27, again, madam, paragraph may not tally.
Okay, 8 and 27.
Madam, this judgment here. 8 starts with, madam, the word. This is not a case where any malafides have been added.
This is lottery matter, isn't it?
Yes, ma'am.
This is not a case. This is how you want, that's what you want to report. This is not a case where the malpractice have been
Yes.
alleged.
Yes, ma'am.
Okay, this para 8.
Then that is fine. And here, my lord, I am relying on the second part of the same paragraph. The only ground of challenge, if your lordship finds, the only ground of challenge in the writ petition filed by Sri so-and-so is that Messrs. Roanoke International did not fulfill the qualifying criterion of having laid such pipeline for distance of 3 kilometers. But the challenger, so-and-so Construction Limited, also does not fulfill the qualifying criteria. In these circumstances, we fail to see any basis for passing the impugn order. And then, my lord, the last paragraph. In the present case, last paragraph. Starting with the word in the present case. In the present case, however, the relaxation was permissible under the tender of the so the relaxation which the board has granted to Mr. So is on the valid principle looking at the expertise of the tenderer and his past experience, although it does not exactly tally with the practical criteria. What is more relevant, I am relying on this sentence. What is more relevant, Mr. So Construction Limited, who have challenged this award of tender, themselves do not fulfill the requisite criteria. They do not possess the prescribed experience qualification. Therefore, any judicial relief at the instance of a party which does not fulfill the requisite criteria seems to be useless. In this case, the writ petition is evidently not eligible because it did not fulfill the required conditions. On that term, there is no question that we can challenge the grant of work in favor of the number 5, the appeal. This is my submission. As the lordship has seen, the basic ground they are saying is that it was there is no bar in submitting 310. There is no bar. The question is fulfillment of the tender condition. Say that you must have a list of packages. You did not have because you submitted immediately to tender for 3 packages at a time. And all the 3 packages were opened on the same. Then it was found that you have submitted same set of documents, in fact, same set of documents containing one set of key personnel and one set of equipment for 3 packages. On this ground, they have shown specific clause of the tender which you have not fulfilled. And same is the case with the, the second part, when and key machinery and key person. And third was about suppression of and finally, in this case, there is another part. Since the question has been kept open about the maintainability of the writ appeal on the ground, that they say that they have one document where the proprietor of the appellant farm has stated in a document which, according to them, is an affidavit, that he has not filed this writ appeal. So since they will be taking up this plea of maintainability, I have to respond.
So who has not filed the appeal?
The appellant. Appellant is a farm, okay. Sole proprietorship farm. The owner of the farm, according to them, has subsequent to the filing of this writ appeal, after the interim order passed, they filed an application for vacating the interim order on the ground that the proprietor of the farm has executed an affidavit saying that I did not file the appeal.
I did not file the appeal.
Yes.
Now, before the writ court.
No. Before the writ court, it was the power of attorney holder of the proprietor. The proprietor never said that I did not engage my power of attorney holder.
Okay. Before the writ court, it was the power of attorney holder who contested on behalf of the proprietor.
Yes.
Now, in the appeal has been filed by
the proprietor himself.
Proprietor himself. So, what is the objection then?
They are taking an objection that there is one document which, according to them, is an affidavit. I'll show my lord why it is not an affidavit, and they have accepted also it is not an affidavit. Based on that, there is one sentence, one affidavit. It was converted into an affidavit, which says that I have not filed any appeal for the High Court challenging this.
The proprietor.
Now,
how can that be?
Then we
file. Appeal is filed.
Yes, filed.
Again, there's another instrument, a so-called instrument, which says that I have not filed appeal.
And I have filed a reply to that IA, saying that the IA is again shown by the appellant proprietor himself, saying that the affidavit which they are showing is not an affidavit. I never appeared before any notary public. And I have also shown that under the Oaths Act, under the Civil Procedure Code, section 139, and also under the Notaries Act and the rules, it cannot be accepted to be an affidavit because there was no identifier. Signature is appearing in one place, name of the deponent mentioned in another place. Then, my lord, on 2-3 occasions, this IE was heard. My learned friend also here, and my learned friend.
So if that is to be accepted, that means there is no appeal.
Yes, that is what they want to say.
No appeal.
Yes. Now, on that ground, or the IE was taken up on 2-3 occasions, my lord, for considering their payer for vacating the interim order on that count alone.
Pleading exchanged?
My lord,
Pleading exchange?
pleading exchange in the IE also. That is why the matter has been kept open.
So as of now, your submission is limited to the appeal only.
Yes. Now, for the purpose of IE, I will be taking 10 minutes to show why the IE also can be considered, and for that matter, we also also. I also will just take up the IA. I'll give my reply on. 2-3 things I'll show, matter nothing much. One paragraph from this document, nothing. IA 1. Lordship is
I just need one thing for the lordship. Because your lordship is on merit, your lordship is heard. So it will be fresh if I give a reply. Maintainability is my application which I've been filed. So once the appeal is being heard on merit, maintainability I can address and my management can give a reply. Because maintainability, I have raised a point of maintainability. Instead of giving a reply, my now appeal has been filed, I cannot give a reply first, then appeal will be heard. So I think, my lord, if your lordships allow me on merit, because your lordship now it's fresh on merit of the case on 3 points. Maintainability, I will, after closing my argument on the merit of the case, maintainability will address, my learned friend can give a reply. There is no problem. Maintainability is I raise the maintainability point.
So probably
technically my learned friend is absolutely correct, but continuing, I can just take
probably for the sake of convenience.
Yes.
Yes, that's why.
He just wanted to point out the.
No, it will be easier. It will be easier. Now, suppose your lordship is hearing the appeal. It is not, I cannot start a case because it is appeal has been filed. So maintainability I have filed. So your lordship is allows. Let me finish his I'll give a reply to his merit of the case. Then my maintainability point can be heard and he can give a reply. If your lordship allows me.
I think it's better Mr. Majumdar finishes whatever objections has raised.
I'll be very brief, my lord. I've got very small certain things. I'll be taking only 10 minutes for this. Lordship will straightway come to para 4, my lord, of the IE. This is
Para
the
4.
P. Yes. I'll be very brief, my lord. Para 4, my lord. Para 4, lordship will straightway come to para 4 that it may be brought to notice of the Solve Court that opposite party farm, Messrs. Tenzing Construction, has
No, just a minute. Okay, it may be brought.
Yes, it may be brought. In the IE,
I-
there are.
I-
It may be brought to the notice of some court that opposite party farm, Messrs. Tenzing Construction, which is the appellant before lordship, was never represented by its proprietor before the learned single judge, inasmuch as it was the attorney who filed the wakalatnama and affidavit. Hence, technically the farm was never before the learned single judge. Further, in the present BTP also, the proprietor of the farm has sworn an affidavit declaring that he has not signed the wakalatnama or he has not filed the appeal before the Supreme Court. Hence, the interest of justice, it is imperative to modify the interim order instruments. That was the prayer. Now, Lordship will kindly see what was our reply.
No, just a minute. Okay. Just a minute. Let some understanding sink in.
I'll be very slow. Now I'll show my what they are saying is.
No, just a minute. Just.
And it should to of this document. Yes. Yes. Necessary. Annexure 2 is the affidavit on which they are placing reliance to make a statement in IEM. But you can say this one-page document, Indian non-judicial, then affidavit, then I see Lobsang Sharing, son of so-and-so, resident of so-and-so, do hereby affirm that I have not signed the Bakaratnama and I have not filed the writ appeal number so-and-so before the Honorable High Court. I further do not want to pursue the writ appeal. My last line says, I don't know, pursue means I filed, but I do not pursue. So it is self-contradictory. If you say that you have not filed, if the statements are to be taken to be correct, my lord, they should have simply said, or it should have simply contained a sentence that I have not filed. Now, last sentence affirms that it was actually filed by him. I further do not want to pursue the writ appeal number 6. Anyway, my lord, what we consider. Now, this document you will also find left-hand side below is the word deponent. Signature is appearing on the right-hand side, and there is no identifier, nor the notary public has come forward to say that I know the person, so there is no question of identification. So that is why, my lord, at page, Lord should we kindly take up the affidavit in opposition which we filed against this IA, and we have given our reply to paragraph 4 at para 8, internal page, my lord, possibly 5.
Just-
20.
There were two affidavits.
And 2, 3.
One is
I'll
objection
yes, one is the Lord should kindly take
and
up.
one is reply.
Yes, one is Lord should take up the affidavit which we filed on 19/6/2025
Yes,
in response to this matter.
yes.
Then paragraph 8 specifically in response to para.
Para 8.
Yes, para 8 of this affidavit. I have replied to their paragraph 4. Yes. Then with regard to the allegation made in paragraph 4 of the application that Mr. So-and-so was never represented by the proprietor before the learned signature as it was attorney who filed the Bakaratnama and affidavit. The deponent states the writ petitioner implicated Mr. changing the section as number 5 in the writ petition to be represented by the proprietor. But since the proprietor executed a notarized, notarized power of attorney on 2/12/2024 in favor of Rajpal, authorizing him to represent the proprietor, said Rajpal filed an affidavit in opposition on behalf of the proprietor, based on which writ petition was disposed of.
What was filed in the writ appeal? Vakalatnama.
Yeah.
There is no affidavit in the affidavit.
Affidavit is not.
Affidavit is not required. There will be a certificate from the affidavit
Absolutely.
and Vakalatnama.
Only Vakalatnama and a certificate by the advocate.
There's a Vakalatnama otherwise.
Yes, Vakalatnama has to be there, my lord.
Signed by the proprietor.
Yes.
And against that now he says that there's an affidavit.
Yes.
I have not filed the appeal. I have not signed the Vakalatnama. I
Now-
don't want to pursue.
Now this affidavit in reply is again sworn by him, the proprietor himself. Now what he's saying, Lordship of the Kinds, para 8.
Where?
This affidavit,
That's-
with your Lordship is reading para 8, my lord.
Just a minute.
The first paragraph itself says, my lord. Lordship has got this reply, my lord.
Anyway, we are not the official, but we just compare the signature.
Para
Okay.
page 7, sorry, the running page 7, the running pages are marked, my lord. Our affidavit in opposition, my lord, on the first page, Lordship, and this affidavit was sworn by the proprietor himself. And he is saying in paragraph 8, which I have just now read, my lord, the Lordship takes that again. With regard to allegation made in paragraph 4 of the application, my lord, Justice,
Yes, we got it.
Honorable says that Messrs. Standing Construction was never represented by the proprietor before the land signature, as it was the attorney who filed the Bakaratnama and affidavit. The deponent states that writ petitioner impleaded Messrs. Standing Construction as document number 5 in the writ petition to be represented by the proprietor. But since the proprietor executed a notarized power of attorney on 12/24 in favor of Rajpal, authorizing him to represent the proprietor, said Rajpav filed the affidavit in opposition on behalf of the proprietor, based on which the writ petition was disposed of. The proprietor of Mr. Changing Construction was therefore duly represented by his constituted attorney before the learned single judge through execution of a wakalatnama and swearing of an affidavit in support of the affidavit in opposition filed on behalf of the proprietor before the learned single judge. A further allegation that in the present case also, proprietor has sworn an affidavit declaring that he has not signed a wakalatnama or he has filed the appeal before the court emphatically denied by the deponent. It may be stated that purported affidavit annexed to the interlocutory application as Annexure 2 is a fabricated document because the proprietor lump sum sharing never appeared before the notary of Government of India, Oni Mipang. Moreover, there is no oath in the said document and there is no indication as to who identified the alleged deponent before the notary. In such circumstances, the content of the said document is neither genuine nor authentic and therefore no order can be passed relying on the said document. It is further pertinent to mention that under the provisions of Section 8 of the Notaries Act 1952 and Rule 11.2 of the Notaries Rules 1956, it is incumbent upon a notary to maintain a register of the documents authenticated by him in Form 15, wherein the particulars of the document, including the signature of the executants of the document, is duly taken. But in the instant case, if the said register is called for, no such signature of the lump sum sharing would be available. In such circumstances, the said purported affidavit is and its contents cannot be relied on, being fabricated document. And then next paragraph, my note that with regard to paragraph 5 of the application, the deponent denies the allegation that farm in question has not approached this court at any point of time and it has only been filed by on the interest of a third party. It is worth mentioning that the instant appeal was filed by the owner of the farm and his constituted attorney, and the applicant is not entitled to pray for vacating the interim order on the basis of certain technical issues which have nothing to do with the merit of the case and the maintainability of the incident. Now, in this,
No, IA was filed for what? Modification, vacation of interim order.
my lord, right. Now, there are
Plus incorporating this affidavit.
yes. Now, in response to my affidavit in opposition, they have again filed a rejoinder, which your lordship will find they have filed. And from there, my lord, I'll show only one thing. Para 7 of that rejoinder is relevant for the purpose of the lordship's consideration. Para 7. That with regard to statement made in paragraph 8, which I have just now read of my counter matter, is denied. The opposite, this is important. This opposite party claims that the proprietary lump sum sharing has executed a notarized power of attorney on 12/24. However, it is to be noted that state power of attorney is neither annexed in the affidavit of issue of the writ petition number so and so, nor in the present appeal. Thus, the claim made by the opposite party is blatant lie and an attempt to mislead this honorable court. The opposite party has alleged that Annexure 2 of the application is a fabricated document on the ground that the person never appeared before the notary. However, the opposite party has not categorically denied that the signature is not his or he has not signed the affidavit. Now, in response to this, my lord, we have filed a reply again annexing that power of attorney. We never thought it necessary, so we have subsequently filed. And this, about this affidavit, my lord, we have made a mention in the counter itself and giving the date.
Power of attorney.
Power of attorney. They are saying that you are not annexing the power of attorney, neither in the petition nor in the writ appeal.
It was not annexed otherwise.
It was not earlier annexed. Now we have annexed.
But was there a statement?
Their statement was that you have not, in response to our.
No. Specific question is in the writ petition.
Yes.
When the deponent filed the writ petition, was there a statement saying that been filed by virtue of power of attorney?
Yes.
Statement is there.
Statement is there, but the document was not
document was not there.
because they never challenged this before the single judge.
And now you have annexed the document
Yes.
in the additional.
Yes. Now in the additional affidavit, internal page possibly, my lord, running page is 81. That was the end of fine. The second last document. Third
Special power of attorney.
yes, ma'am. The special power of attorney is executed on 2/12/24. This date we have mentioned in the, and Lord will kindly see the nature of this power of attorney. 3 pages, signature is there, executive was shown before an executive magistrate who administered the post minor, giving the name of the witnesses. Executant signature is there on all pages, and it is a notarized one. And for this, I'm just showing one.
What is the signature of this Lobsang setting?
In the affidavit manner,
And the power of attorney.
no, Lobsang saying has been, yes, ma'am. Right hand side manner, page 80, right hand side, on all the pages, ma'am.
There are what, 2 signatures.
Yes, one short and one long. After the NIT was issued, NIT was issued in July 24, so December 20.
That's it.
And for this, I have to just show that this affidavit on which they are relying. First of all, from the appearance of the affidavit, finally find that name is even here, the bonus is there is no identifier. For that matter, I'm just relying on one of the provisions of the Notaries Act manner. It can be accepted in affidavit. They are saying that this is an affidavit.
Something wrong with the setting in the computer.
No, madam. Computer, alright, that is there.
Typing, when you type, you see
Sometimes doesn't get.
left side come on the right side, right side on the left side. All these things happen. And
Now,
plus,
I say that had I shown the affidavit before the notary public, then the Notaries Act and the rules require that the notary public will maintain a register there. He will take my signature. I never appeared before him, and this requires that you have to put signature. They have to maintain a register under the rules. May I show this?
mentioned it.
My life and CPC also requires, and the oath sect also requires. And for that matter,
How do we enter in all those disputes?
yes,
In a writ appeal or in a high.
and Manu, just lordship, take note of your lordship. If necessary, your lordship will consider. There are 2 judgments which say that when and how an affidavit can be accepted.
Yes, what are they?
1984 supplementary SCC. Yes, 84 supplementary SCC, page 571. M. Veerabhadra Rawat, Section. Para 17. Para 17 says, it has to be signed in the presence of the person who will administer. I said I never appeared. Take para 17. The expression affidavit has been commonly understood in a sworn statement in writing made specifically under oath or an affirmation before an authorized administrative officer. Affidavit has been defined in subclause 3 of section 3 of the General Clauses Act 1897 to include affirmation declaration in the case of a person by law allowed to affirm or declare instead of swearing. The essential requirements of an affidavit are the statements or declarations are made by the deponent relevant to the subject matter, and in order to add sanctity to it, he swears or affirms the truth of the statements made in the presence of the person who in law is authorized either to administer oath or to accept the declaration. The responsibility for making precise and accurate statements in affidavit were emphasized by this so the part or the role assigned to the person entitled to administer oath is no less sacrosanct. The just last one judgment. 2013 10 SCC. Para 39 and 40. Paragraph 39 and 40.
This is also an affidavit.
Yes, madam. 2013 volume 10 SCC 591. Mesh Kumar versus State of Andhra Pradesh. Para 39 and 40 madam. Just small paragraph. Very small. Attestation of the undated affidavit is in utter disregard to the provisions of section 139 of the Civil Procedure Code. The Supreme Court rules 1966 under so require adherence with the provisions of section 139 CBC. Hence, this reply is not worth taking on record and being undated, rendered same to be a piece of waste paper. The definition of affidavit in section 3.3 of the General Process Act provides that it shall include affirmation and declaration in the case of a person by law allowed to affirm or declare swearing. Thus, it is an essential characteristic of an affidavit that it should be made on oath or affirmation before a person having authority to administer the oath or affirmation, and thus duty to state on oath on the part of the deponent is sacrosanct. The same remains the position in respect of administration of oath as required under the Oath Act 1873. I think the position around this document which they have relied on in the IA change the maintainability on the ground. My lord, the relevant provision of Oath Act is section 3. Just take note of that. Section 3 of the Oath Act 1969. Says my lord, person may be only a person who is empowered in law will administer. So just to summarize, my lord, I'll make one submission. Oath Act lot is what. Section 3 administer. 1A says all who and persons having by law or consent of the party authority to receive evidence in there than subsection 2 without prejudice to the powers conferred by subsection 1 or by or under any other law for the time. Any court, judge, magistrate, or person may administer oaths and information for the purposes of affidavits if empowered in detail. Then section 4 says oaths or information to be made by witness, interpreter, etc. So, in view of all these provisions, when I specifically say that I never appeared before the notary public, you can check the register because compulsory rule says of the notary rules compulsorily he has to maintain a register where he will take my signature and he will mention about the affidavit. Since it was not, I never appeared. They have procured, they have made this document. That being the position where the IA can be considered, it can be the document can be considered to be an affidavit in the eye of law, and then in course of hearing all this, I even once my friend quite fairly exceeded that yes, it's not an affidavit in the eye of law as such. Well, my submission of, as far as this maintainability is concerned, my lord, one thing is very important, my lord, which you also will consider. The proprietor himself is not saying that I have not filed the Wakalatnama, that there is a dispute with the power of attorney holder. I never authorized him to contest the petition when the petition was filed or to file the affidavit. There is nothing like that. He filed an affidavit here before your lordship in response to their IA. On oath, he has stated that it was filed by me, and it was on the basis of my power of attorney of 2024 which he contested the petition. Then the petition will decide on merit, and since there is no overwhelming public interest, the lordship may not there will be in order and the meeting order pathway on that will get that is my solution.
Very physiological. My lord, I participated in this tender, and your lordship has looked into that there are 3 clauses on which the authority has rejected my technical bid, declared as non-responsive. 4.4 BB1, 4.4 BB2, and clause 4.71, which your lordship, my learned friend, has shown. On this particular, it was declared as non-responsive. Now, this was put to challenge before the learned single judge. Now, my learned friend has not projected what is the case which I projected before the learned single judge, how it was dealt by the learned single judge. Now, I'll just tell your lordship without opening the brief, then I will go to the judgment of this court. You'll be better understanding. 4.4 BB1, on which ground? First ground is that I should submit the plant and equipments machineries before the authority concerned, which I did. Now, there is no clause. Your lordship will kindly look into it. There is no clause looking that if I have done 3 projects, 3 different equipments and plant and equipment machinery is required. Nowhere it is written in the terms and condition. Nowhere it is written. That is not the stand taken by the government. That's very important. This is what my learned friend is taking a stand. How we will do the work. I'll show how the learned single judge has dealt this issue also. There is no terms and condition that this is requirement of 3 different projects, 3 different plant and equipments has to be provided. Technical personnel differently you have to provide. There is no terms and condition. It has not been laid down. What is required is availability is required. If your lordship looks into it, the 4.4 B 1 and 2 for a quick particular look at page 64, kindly see page 64. What is requirement? What is required? Kindly see at page 64. Each bidder must demonstrate 1. Availability for construction work. Where is that? My learned friend has projected. This is not the stand taken by the government. My learned friend cannot take his own stand that this is required. How can you execute the work on 3 different sites, all the plant and machineries, equipment? How can this is not the stand of the government? Neither it is terms and condition. It is not covered. What we have to show, demonstrate, is my availability for construction work. These plants and equipments I have to show. That's all. If your lordship not turn to page 65, 44 4.4 BB2, kindly see next page. Availability for construction work of technical person. Where is that? That I will not be able because on 3 different projects, how can you execute the work? This is not the terms and condition. Availability only I have to show. It is my headache. 4.4 B1 first, which I have been rejected. Page 64, kindly see page 64.
4.4
B B1, B Roman 1. 4.4 small B, capital B and small b 1, Roman 1. Each bidder must demonstrate availability for construction work, either own or on lease or on hire, of the key equipment stated in the appendix of ITB, including equipment required for establishing field laboratory to perform mandatory tests and those stated in appendix to ITB. This is what is required.
And 65.
And if you see 65, 4.4 B2, Roman 2. Kindly see Roman 2. Availability on top. availability for construction work of technical personnel as stated. So that's availability only we have to show, demonstrate. It is not that what my learned friend, that is his own argument. How we will be able to proceed with the work, because suppose I have given 3 different works for a moment. How I will proceed with the work? If the same plant, equipment, machinery, technical, but that is his argument before the court. That was his argument. That was not a terms and condition of the NIT. I could have very well understood that a terms and condition, like my lord, I have been told in ONC for drilling, my lord, site, that machinery equipment separately you have to give. Those terms and conditions are laid down in the NIT. Your terms and condition, my lord, has to go strictly with the terms and condition. The employer, these are the terms and conditions of the employer. This strictly has to be followed. But this is how the learned single judge also dealt his argument. Learned single judge, I'll show it. That is why I'm saying 4.4 BP1 is only.
Mr. Das.
Yes.
Just interrupt.
Yes.
Normally, there is a break for 5 minutes and 12.
Yes, yes.
Can you just rise for 5 minutes?
Yes, yes, of course, of course.
You have single benches also today.
I will try to finish it off.
Ma'am.
No, I'll just try to finish it off before your lordship rise.
No, you must argue all your points. Not that we are much enough things.
No, I will just try. I'll just try to satisfy your lordship by not opening and just pointing out what is the case about and how it is dealt.
Yes, Mr. Das.
At our days, we didn't have all these equipments, all the technology. My friend also, I think your lordship also, we didn't have all these modern, all facilities what we get today.
But
I find it very difficult sometimes. Now iPad, your lordship, is everyone is learning and everyone is now throughout an iPad. See, liquid text is there, that no paper, nothing. So I find it very difficult, but I have to learn. Even then, we have to learn.
In a tab method, on the one hand, there is a liquid test for which no brief is necessary.
Yes.
And on the other hand, if you have in the same tab all the journals, app, then nothing, library is also not necessary. In one life method, we have seen everything started from a stage where there was nothing. For every small point panel, we have to go to the entire rack. So your lordship is aware when the Supreme Court 2 volumes, except 1969, there is only 1 volume. All are 2 volumes and High Court volumes. So for small matter in CPC, small provisions matter doesn't go up to high Supreme Court level. So High Court journals, so each High Court has been seen. Now,
and Supreme Court digest, you also remember green and red. There's 2 digests where they're green and red. SC, Supreme Court digest.
The yearly digest.
The yearly digest. From that you have to find out case laws. You have to find the case laws.
Malik's there.
Malik. Correct.
Everything. You just cite one judgment, you get everything.
Matter not to talk of these apps, journal. Google also says,
Yes.
Google gives
Correct. AI.
yes.
AI. Chat
Then-
GPT. I think
Correct.
I have something Chat GPT.
ChatGPT
You
is-
prompt it and the petition is made. I don't know. Some junior came and said, I don't know, how is it becoming so good now in writing? Now I have found that he used Chat GPT.
Some writings, we are online, I cannot say where, but some writings show possibilities through ChatGPT. some writings I'm saying, your lordship
Uh-huh.
will understand.
Yes, yes. One has to be careful. Anyway, you can make use of this, but it will not replace the human
Not
part.
obvious.
The human thing
That's
is what's
right.
necessary. And I, for one, come back from the old school. I prefer handling the book,
Yes, even
turning the page.
even me, my
That is
You have the
same.
feel. Instead of getting a printout,
Same here.
touch the book, have a feel of that.
Well, the
You feel
other day, I volunteered and rather mastered courage to appear in one case of for one apex school. My learned junior was repeatedly saying, "Can't you do the liquid test? Damn." Said, I'm somehow not very conversant, not very comfortable with this. So I carried the papers. Because the FJ Rosh from the old school.
Yes. Now,
Alright,
my lord,
yes.
we left 4.4 B Roman 1 at page 64. Your lordship at page 64 has looked into it.
Yes.
This is one of the criteria to qualify, but what has to be is see the bidder must demonstrate availability for construction work. Lordship has looked into it.
Availability.
Availability. Now you say, please turn to page 65. Now same here, availability for construction of technical personnel as stated in so and so. Now I'll show one particular clause, how you qualify at page 66, kindly see, 66, 65. Page 65, page 65, kindly see page 65, immediately thereafter, after this 1, 2, availability, see 4.4C, to qualify, what you got it?
Yes.
For a package of contracts made up of this and other contracts for which bids are invited in a notice inviting tender, the bidder must demonstrate having experience and resources sufficient to meet the aggregate of the qualifying criteria of the individual contract. This is how you qualify. You have to show, my lord, you have to demonstrate that you have an experience and resources to meet the aggregate of the qualifying criteria of the individual contract. This falls under 4, page 62, qualification of the bidder. Kindly see at page 62. It falls under that criteria only. Qualification of a bidder. See qualification of bidder, clause 4, which falls under that criteria only, which at page 65, 4.4C, inclusive of qualification of a bidder. But that's what is required. 4.4 B1, it requires only for the purpose availability of equipments and machinery. And 4.4 B, B2, it is only availability of construction work of technical person. This is what is required. And see base. Now these are two criteria where they disqualify me because it's saying that it is non-responsive. Another ground which they have disqualified is kindly see 4.7 at page 66. 4.7(1). Even though the bidders meet the above qualifying criteria, they are subject to be disqualified if they have 1. Made misleading or false representation in the form, statement, affidavit, and attachment submitted in proof of qualification, requirement, and or record of so and so litigation. It is so and so. So this is somewhere some misleading or false representation. Suppose there are some few cases pending litigation which has not been disclosed, and in the this is not been we misled because in the representation of the forms we have to state that has not been stated. So that is one of the ground where they can reject. So if your lordship now looks in the impugn order, these are the 3 clauses which my bid was rejected. Technical bid was rejected. Now where you find that? Page 143, my lord. See 143, which my learned friend has already shown. 143. This is 2nd of August 2024 at 143. Now if your lordship looks at 144, Now Lordship has found that mine is at serial number 4. Your Lordship has marked anti-agency non-responsive. Attracts 4.4BB1, attracts 4.4B2 and 4.71. These are the 3 grounds. Now, why the learned single judge has said and refer to the judgment of Mohinder Giri? Because if you see the impugn order which they rejected, there is no reasoning. Maybe 4.4B1, 4.4B2 and 4.71. Under which ground? There are so many. Either I disqualify because of planted equipments or disqualify the availability of construction of technical personnel or misleading, which is the ground. You have to spell it out. It has not been spelled out in the impugn order. Now, these 3 particular issue, which my lord, they have rejected my technical bid, I came up before the learned single judge, challenging these 3 grounds. Now, my argument before the learned single judge, I'll just say in short, what was my argument, how it is dealt. My argument before the learned single judge is that you could not have rejected my technical bid on the ground of 4.4B1 and 4.4BB2. Simple because similar contract in respect of PMGRY, in respect of the same, my lord, the person, who assessed, they were the same person who assessed, they did not reject it. Similar nature of contract, in respect of, this is a different package, another package. Same plant equipments was given, same construction of technical personnel was given, they did not reject it. They accepted.
That was before rejection of this one or before?
No,
After.
yes.
After.
Yes, I'll show it. I'll show it, my lord. 28/10/2024. Let 28/10/2024 was the another contract where they have.
Where do we find that?
Which one, my lord? 10/2024. That is 379. Your lordship will get it. I'll show that your lordship now. I'll just give a date and how it is dealt by the learned single judge. That I will show it, my lord. My argument before the learned single judge was that in respect of another NIT, in respect of another package, you have accepted the same plant equipments and machinery and the technical personnel. So how could you have rejected on, and your lordship will kindly see what is the rejection ground? Rejection ground, they have improved it in the affidavit. What they say, one of the equipments which I submitted before the authority concerned, that was a fake invoice. This is the ground. Fake invoice which I have submitted before the authority, the equipments which I submitted. They said, what I find and why I reject is that you have given a fake equipments in one of the invoice. So that is one of the ground that we have rejected. So that is also, they could not have rejected. So they brought an affidavit and they said, this is on the ground that we have rejected. But the same, my lord, the person concerned, the evaluation committee, they considered on the basis of same plant and equipments and machinery. How could they have rejected it? That's our contention before the learned single judge. And 4.7, now going back to 4.71, our contention before the learned single judge was that even then we have not submitted the pending litigation, one of the pending litigation, the private respondent also had the litigation. So they did not also submit that pending litigation. Now the argument before the learned single judge by the private respondent, maybe we have not given. That has been awarded to us. We were respondent. That is what it is not required. Learned single judge, it cannot be. If the pending litigation you have not given, it cannot be only to respondent where pending litigation is not required. If that be the case, then the pending litigation is not required for the present petitioner who contests the case. So how can you say that it is not meant for you, but it is meant for the petitioner? That cannot be a ground. So on this free ground, the learned single judge was satisfied on this free ground. And the learned single judge said that this particular issue, which you are bringing before the court by way of an affidavit, how can you bring it? Because the order, impugn order, speaks about something else. By affidavit, you are trying to improve your case. That is why the judgment has been relied, Mohinder Singh Gill. Now, I'll show how the learned single judge has dealt this particular issue. Because my learned friend has started reading a paragraph of 21. But what is the case and how it was dealt? I'll take a quick look. Your Lordship will kindly see the judgment. 376 it starts. 376 it starts. Kindly see at paragraph 379 at paragraph 5. This is how we project it. This will be clear, my lord. At paragraph 5, my lord, may I read paragraph 5? Mr. Sri Therefore, the learned counsel for the petitioner has submitted that for communication dated 2/8/2024, 3 classes have been cited for rejecting the technical bid of the petitioner. He has submitted that neither of the 3 clauses are applicable in the case of petitioner and therefore could not have been taken into consideration for rejecting the bid. He has submitted that the first clause, 4.4b1, relates to the list of equipment and machinery which the petitioner has given as required under the NIT. Similarly, clause 4.4b2 is on the requirement of list of technical personnel, which also submitted in accordance with law. He submits that the last clause, namely clause 4.71, is one of the aspects of giving misleading statement or misrepresentation or having a record of poor performance. He submits that the said clause will not have any application at all, as there were no instance of giving any misleading statement or misrepresenting any facts. They now kindly see 6. The learned counsel has drawn the attention of this court to the list of equipments and the list of technical personnel submitted along with the bid, which have also been annexed to the writ petition. He has submitted that the illegality of the impugn action becomes apparent inasmuch as another contract which was initiated by an NIT dated 28/10/2024, the petitioner was declared qualified, and in the said NIT, the same documents were given in the tender process. He has submitted that the said aspect has not been denied by the department in this affidavit. He has submitted that it appears from the affidavit or department that certain other aspect has been taken into consideration, namely the certain invoices of the machineries were not genuine and there was no disclosure regarding any pending litigation. Sri Therefore, learned counsel has submitted, apart from the said aspect being relevant, those were not mentioned in the communication dated 28/10/2024 and therefore could not have been raised in the affidavit. He has also submitted that on merits, both of the allegations are absolutely incorrect and categorically denied. He has submitted that the aspect that the invoices of the machinery not being genuine cannot be countenanced inasmuch as the same list of machinery was accepted by the same department insofar as the order work is concerned, which was initiated by NIT dated 28/10/2024. As regards the non-disclosure of pending litigation, the learned counsel submit the same cannot be taken into account to disqualify the bid as it would not have any relevancy on the evaluation of the bid. He submits that the pendency of the litigation would not have any connection with the aspect of a bidder being technically responsive. He otherwise submits that if that be a reason to disqualify the technical bid of the petitioner, even the respondent number 5 had a litigation pending before this court, and the response of the department was that in the same litigation, the respondent number 5 was only a respondent. He submits that approach of department has been discriminatory, and on the same ground, the bid of respondent number 5 has been treated to be valid, whereas the bid of the petitioner has been rejected. The learned counsel for the petitioner, now for 7, my lord, kindly see judgment Tata Cellular, all this has been. Now, my lord, kindly see at paragraph 9 at page 382. Opposing the writ petition at page 382. Lordship finds it. Opposing the writ petition, the Tarak, the standing counsel for department, has at the outset clarified that PMGSY, there is no restriction in participation as it is a global tender, and in fact the petitioner has participated in 4 packages. he submitted. It's a matter of fact that 2/8/2024 technical evaluation was done for 3 packages, wherein the same list of machines and same list of technical person was verified. Now kindly see, that is his own statement which is made by the Standing Council or Department. 3 packages were assessed, same list of machinery in the same list of technical person. So how could you have allowed 24/10/2024? However, the work which the petitioner is claiming to be successful is of a different package, which was opened on 28/10/2024, which is subsequent to the present work. He has submitted decision to hold the petitioner successful in another work is a subsequent decision which cannot bind the department in the previous decision which was taken on 2/8/2024. He has also highlighted the aspect that allegation that the invoice of the petitioner was found to be fake as not categorically denied by the petition. Now, my learned friend has cited one judgment of the Supreme Court, paragraph 10, Galaxy, order judgments, Jagdish Mandal, my lord, your lordship will skip 384, judicial review where it can be done, Jagdish Mandal, 387. Now, paragraph 13, which my learned friend has read, 387 in paragraph 13. The Learned Standing Council has submitted that the construction of the road in question is in the border areas and immense public interest involved. He has submitted execution of the work is going on smoothly, and at this stage any interference would not be in the interest of justice. He also submitted by this time e-portal perhaps has been closed, and therefore it is not possible to have a financial evaluation if the petitioner is successful in the writ petition. Now, my lord will kindly see the part, paragraph 14, my learned friend has already read his particular argument, what is in advance before the learned single judge. Now, paragraph Ronak, now your lordship will kindly see the finding at page 391, the finding of the learned single judge is most important. How the learned single judge has dealt this issue of 3 particular clauses where I was rejected. 391, paragraph 20. The finding of the learned single judge. The impugned order of rejection dated 2/8/2024 has cited 3 clauses of tender document under which the technical bid of petitioner has been rejected. The clauses has been elaborately mentioned above. Now, para 21. As per the first clause, there is a requirement to give a list of the equipment and machineries. As per the second clause, the list of technical personnel is to be given. The impugned order does not specify or cite any details of invocation about the aforesaid 2 clauses, and in the affidavit, it has been stated by department that in the list of machineries, certain invoices of machineries were enclosed and has been stated to be not genuine. Apart from the fact that the aforesaid allegation has been denied by the petitioner, the court has found that the said reason has not been disclosed in the rejection order dated 2/8/2024 and clearly appears to be an elaboration made in the affidavit by the department. What the learned single judge says that in an impugned order which was passed, you have not disclosed the reason. You have taken this point in the affidavit. Now, he goes to para 22, my lord, and 2 judgments were cited. One is Commissioner of Police and one Mohinder Singh. Now, kindly see how it is dealt. It has been clearly laid down. Public orders publicly made has to be examined on the basis of reasons cited in the said order, para 22, and cannot be improved by way of an affidavit. The aforesaid observation of Honorable Supreme Court has reiterated in subsequent cases, including the case of so and so. Relevant paragraph so and so is so and so. So my learned friend read this relevant paragraph. Now see para 23, which is important. Para 23, my lord. The court has also noticed that in the subsequent NIT dated 28/10/2024, petitioner was declared qualified in the technical evaluation. It is the emphatic and categorical case of the petitioner in this NIT also, same set of documents pertaining to the list of equipment, list of technical personnel have been submitted. Though the learned standing of department has tried to justify said NIT is of subsequent period, which should not bind the department for a previous decision, this court is unable to accept the said contention inasmuch as it is the same department which has found in same list of equipments to be acceptable in a subsequent NIT, and therefore the first 2 grounds of cancellation by simply mentioning the clauses are clearly untenable in law. This is the first two grounds where I have rejected that this is the reasoning of the court. Like could not have been done because the same department where they found the same list of equipment. How could? Maybe it's a different NIT, different date. You could not have rejected. This is the first ground. Now kindly see para 24. What remains now to be examined is the invocation of clause 4.71, which pertains to making misleading statement or misrepresentation or having a record of poor performance. Apparently, the said power is discretionary in nature and it is a settled position of law. Whenever discretion is applied, same has to be done by following the due process and with due care and attention. In the instant case, department has tried to justify invocation of the said clause by citing that the petitioner has not disclosed pendency of a litigation in the High Court. The response by the petitioner is that even the response number 5 had a litigation pending in the High Court, which was not disclosed. The explanation by the learned counsel for the response number 5, as well as department, is that in the said litigation, the said response number 5 was in a position of a respondent, and therefore there was no requirement of such disclosure. The aforesaid explanation cannot be countenanced in view of the fact requirement is for disclosure of pending litigation without any further stipulation as to whether the party was the petitioner or a respondent. So this is the ground where again the learned single judge has said you cannot, it's not meant only for the petitioner, it is also meant for the respondent. He also has to be disclosed. Now kindly see para 25. It's very important. As regard the issue is to the progress of the work, whereas the private response department has contended sufficient work has progressed at department contention is that almost 50% of work has progressed. On the other hand, the learned counsel petitioner has submitted that at best 30% of work has progressed. The progress of the work is undoubtedly a relevant factor in as much as the same touches upon the aspect of public interest. At the same time, rights of the party cannot be denied only on the ground that the progress has been made. Even in a given case, the progress was of substantial nature, matter would have been different. However, in instant case, progress is not that much substantial. My lord, this is what my learned friend has submitted before the court. Substantial progress has been done. Maybe he may say 70% of the work has been accomplished. Maybe a nature of a public interest. Even then, whether your lordship can interfere or not, I will show one judgment of the Supreme Court. Even then, a contract was terminated. The agreement was set aside. I'll show one judgment. Even then, it is possible for the court. Now, kindly see, my lord, paragraph 26. The scope of interference by a reed court in a matter of contractual dispute is circumscribed, and it has been clearly laid down in a number of judicial precedents that such interference can be made only when there is gross arbitrariness and unreasonableness if the impugned decision or the same is vitiated by malafide. In the instant case, the reasons which are discernible for rejection of the bid of the petitioner apart from being scriptic are not consistent at all, more so by the subsequent action and the conduct of the department itself. Now, my lord, what I understand from para 27, when the proceeding was going on, deliberation was made by the counsel, the court has asked the petitioner, what is your rate? What is the rate you have quoted? We want to know it. Otherwise, it will be meaningless, futile exercise. Suppose your rate is L2, L1 is my learned friend, then it's useless of hearing the he asked. So there was a response which was given by my friend who represented on behalf of the petitioner that his is lesser rate than the rate which is quoted by the appellant's client. So if you see para 27, kindly see, this court has also made a specific query to the petitioner regarding the price offered by him, and it appears that the price of the petitioner was lower than the contract amount which was offered by respondent number 5. The said query was put so as to ensure that the present exercise of adjudication does not become a futile exercise. Now, operative portion, my lord, in view of the aforesaid facts and circumstances and discussion made above, this court is left with no other option but to interfere with the impugned order dated 28/10/2024 by which the technical bid of the petitioner was rejected. Consequently, all consequential action, including the issue of the letter of intent and the work order in favor of the respondent number 5, stand interfered and are accordingly set aside. The remaining part of the work is to be assessed and the same is required to be allotted to L1 bidder who is found eligible in accordance with law. It is, however, made clear, so far as the work done by the respondent number 5 in the meantime is concerned, there will be no restriction toward payment and release of the bill to the said respondent number 5. So this was allowed in a matter indicated above. So these were the 3 grounds which was considered by the learned single judge. On 3 grounds your lordship has looked into it. That one, the court said that you could not have rejected his technical bid on the ground of 4.4b1 and 4.4bb2 on the ground that you have accepted in another NIT the same equipment machinery. How could you have done it? And the stand which you have taken in the affidavit is after the impugn order which was passed. You cannot bring it by improving your case by filing a way of an affidavit. That was the view of the learned single judge. That is why Mohinder Singh Gill was cited, because if your lordship looks into the impugn order of 2/8/2024, it does not say anything on what ground it has been rejected. They only mention these 3 clauses. And they try to improve by way of filing an affidavit. One, they said that some invoice which you have submitted, list of invoice, one list of invoice which you submitted, it appears to be fake. That's what they have brought it by way of an affidavit before the learned single judge. So now, my lord, my case is that I think there is nothing we find irregularity or something perverse in the judgment of the learned single judge. Now, what is the stand? Now, very important aspect of the matter. They prefer an appeal against the judgment of the learned single judge. Now, who has preferred this appeal? The appeal has been preferred by the proprietor. Kindly see, the proprietor has preferred this appeal. If your lordship looks into it, the appeal has been preferred by the proprietor of the fund. Page 3, kindly see, on the writ appeal. See at page 3, the engine constructor represented by proprietor Lobsang Tesway. Got it? He has preferred. Now, our case, which we came up before the division bench and said that apart from the merit of the case, now I projected what is the merit of the case, how it is, how counteract what he said, my learned friend said. But so far as the maintainability, I have also taken a point. Before taking the point of maintainability, I like to address your lordship regarding at 422, the affidavit filed by the private respondent before the writ court. Kindly see at page 422. 422. Kindly see. I see Raja Pau, authorized representative of so and so. Now he doesn't project that it is by way of some power of attorney was given. My learned friend is all the time is saying it's a power of attorney, power of attorney. There is no power of attorney. It's a huge difference, authorization and a power of attorney. I'll show before this court. And kindly see paragraph 1 at page 423. See paragraph 1 at 423. That Messrs. Tenjin Construction has aired a respondent number 5 in the aforesaid petition, and the Lobsang Tenjin proprietor of so and so was duly authorized me to sign or file affidavit relating to said tender work. So as such, I am well conversant, acquainted with the facts and circumstances of the case. I am authorized to sign and swear this affidavit. So now, if you see at page 431. Kindly see 431. C431. This is what he submitted before the learned single judge. There is no power of attorney. Kindly see letter of authorization. Kindly see what manner he submitted. 1711. I see so and so, changing construction so and so. Do hereby affirm and declare on oath as under. I authorize Rajpal so and so to represent my firm in legal matter of what? Namely so and so, wrote from so and so. So this is the authorization letter which he has annexed in the as a response number 5 in this case. And this case was represented by Rajapal. Now, if your lordship looks into it, page 3, now kindly see page 3. Kindly see the appeal and page 3 again. Now, who has filed this appeal? Kindly see page 3 again, my lord. See page 3, my lord. Page 3 of the memo, appeal memo. Page 3. This is filed by Tenzing Construction, represented by proprietor Lobsang Tech. Now he comes up before the appellate court. Now this particular, the proprietor was not before the learned single. That's my case. He is not aggrieved person now. My lord will kindly see, this is very important. My lord will kindly hear me. He is not an aggrieved person before the bench. He has to be aggrieved by the order passed by the learned single judge. Whether any authority given, authorization given, whether it is tenable in the eye of law, it is only power of attorney is tenable in the eye of law. You cannot bring it subsequently. We had that power of attorney. We have not brought that power of attorney. My lord, that's a very important point here. That's why what we have done it, when the writ appeal was filed and there was a stay which was granted, we came up before this court for vacating of the stay order, not only one count. We said that your writ appeal is not maintainable. How it is not maintainable? We said that throughout your proceeding before a writ court as a private respondent, it is represented by one Rajapal, who you say that it has been authorized. Wakalatnama, have your lordship found any wakalatnama to be filed by the authorized representative? It is only through a power of attorney where an wakalatnama is being filed, not an authorized representative. Now this Rajapal, that is why we brought in affidavit. My lord will kindly see. Just 2 minutes, my lord. Kindly see the affidavit where we brought it. Now kindly see at page 38 of my affidavit in reply against the affidavit. This is an IA. Yeah, yes, IA. Kindly see, my lord. It will be clear now. See, IA. IA 152 AP 2025. IA. See page 38. Lordship got it, 38. IA. Affidavit reply. See the wakalatnama. Lordship got it, the wakalatnama. My lord, Honorable Justice couldn't, I think, got the wakalatnama at page 38. Page 38. Kindly see now, this he files wakalatnama Rajapal. I have not come across a particular authorized representative comes and files a wakalatnama. It is to a power of attorney. Power of attorney name will be there. Where is that? Rajapal comes. We don't know who is Rajapal. Somebody representing on behalf of proprietor, he projecting himself. He said that I've been authorized, that authorizing letter, wakalatnama is filed by Rajapal. Now kindly see, and in the appeal at page 43, same IA, kindly see page 43. Now this is represented by the proprietor. Let us say that he has proprietor represented. But can he be an aggrieved person against the order passed by a learned single judge? He was not a party before the learned single judge. This is what we said, that this appeal is not maintainable. Appeal is not maintainable because he is not a party before he is not an aggrieved party before the read court of filing a response as a response number. He is not a bidder. Bidder is tenant, is proprietor. What authority you have got? Is it through a power of attorney? You have not produced any power of attorney. He admitted, my lord has asked a question to my learned friend. I remember today in the morning session that whether any power of attorney, your specific word was power of attorney, has been filed. He said, no, we did not file. We made a statement. Where is the statement? I have shown paragraph 2. There is no statement that it is represented through a power of attorney. It is authorization letter. So this particular appeal is not maintainable. You are not an aggrieved person. You cannot challenge an order of a learned single judge. You are not an aggrieved person. You have only authorization was given. What is the value of now, my lord? When the I was filed, reply was filed. Now thereafter, a court directed, division bench directed that you have to come with a clear picture. Whether they now in response to that, what he does, my lord, a power of attorney, he annexed one power of attorney. Kindly see that. In this case, kindly see. Page 81 kindly be seen, my lord. Page 81, IA 81. See, now he comes up with in IA, he files a reply, additional affidavit, and he brings this power of attorney before the court. Now kindly see, this special power of attorney is executed on the 2nd of December in the year 2024. Know all these men so and so. Now kindly see at page 82, appoint nominate Rajapal, and see now, whereas so and so appoint pleader, lawsuit sign Vagalatnama. Now and 83 is his signature. What? Why you have not brought this power of attorney before the learned single judge? Because you did not have that power of attorney. You brought the power of attorney before a division bench, not before the learned single judge. And this is executed in 2024 and before a magistrate. Before whom? Kindly see, my lord, executive magistrate. Now a power of attorney, I also want judgment. It has to be registered compulsory. Executive magistrate. Your lordship has looked into it. That is what my ground is. Maintainability is that ground. Not only ground and my learned friend is a vacating of this stay. No, this is my ground. When I started my case, that your writ appeal is not maintainable, court said, okay, we'll keep it open. Maintainability point. Now, your lordship doesn't have to trouble with the merit of the case. But I have given a reply, so merit of the case is concerned. Merit of the case. I could have started with maintainability. That your lordship, all this, the matter has been heard on merit of the case. My lord doesn't have to hear on merit of the case. I'll argue on the maintainability point. That whether your lordship will entertain this appeal or not. I could have said, but I thought that let me argue because the learned division has said, you argued on a merit, maintainability will be kept open. So now the question boils down that whether this appeal is maintainable. Merit of the case, I have given a reply, your lordship will consider that part. But kindly see, one judgment of this court, division bench of Itanagar bench has already decided. What is the power of attorney? What is the power of the value of a power of attorney? How it is being dealt, whether it can be entertained or not. Any authorization letter. Kindly see Rajapal, 2015, 5 GLR, page 147. This is pertaining to Itanagar bench, division bench. My lord will kindly see paragraph 3, my lord. Paragraph 3. This is lordship, please note down it is on the point of maintainability. Page 3, my lord. by the said, Your Lordship got it? By the said undated authorization letter, Your Lordship, that's an authorization letter. The appellant was only authorized to collect, receive, and submit tender document on behalf of Lokman Brothers. In course of hearing, before the learned single judge, R.M. Nabam, learned so and so, seriously questioned the locus standi of the appellant, submitted that the appellant is not an aggrieved person, and no power of attorney has been issued by Messrs. Lokman Brothers in favor of the appellant writ petitioner, and as a writ petition was not maintainable on account of lack of locus standi. Accordingly, Nabam learned so and so, the appellant has no authority to issue a legal proceeding on behalf of Messrs. Lokman Brothers. The said objection raised by Nabam was duly considered by learned single judge on the material available on record, and by detailed judgment touching upon the basic facts and the point of Locus dismissed the writ petition by judgment and order dated so and so. Now, paragraph 5. There is no manner of doubt that in the writ petition, no document, kindly be marked. There is no manner of doubt that in the writ petition, no document was enclosed showing the petitioner authority to act and to institute a legal proceeding on behalf of Messrs. Lokman Brothers. The only document annexed thereto was the undated authorization letter as quoted. T. Sohn, learned counsel for the appellant, submits his prayer for withdrawal. The writ petition was liberty to file a fresh writ petition, not having acceded to, and as a judgment order passed by learned single judge cannot stand the scrutiny of law. The issue before this court is to whether the appellant is a person aggrieved and has a locus to represent Messrs. Lokam Brothers, short any power of authorization in the form as required under law. 7. The concept of locus standi for filing a petition under Article 226 of Constitution have received consideration in category of decision rendered by Apex Court. In this context, reference is made in so and so. The consistent view of the Apex Court in respect of concept of locus standi makes it clear, although the expression aggrieved person denotes an elastic and exclusive concept, however, the person approaching the writ court must necessarily show the extent of his interest as well as the nature and extent of prejudice or injury suffered by him. In other words, an aggrieved person is one who has a particular or peculiar interest of his own. In a reported judgment, the Apex Court has further elucidated that a person aggrieved must be a man who has suffered a legal grievance, a man against whom a decision has been pronounced, which has wrongly derived him of something or wrongly refused him something or wrongfully affected his title to something. In fact, Apex Court has laid down that to have locus standi in invoking extraordinary jurisdiction under Article 226, the applicant should only be one who has a personal or individual right in the subject. Where is that in this case? Somebody authorized is not being recognized as law by the Supreme Court or by the High Court Division Bench. Kindly see 8. From the available record, it is apparent appellant is not a person aggrieved. He has not submitted document to show under what circumstances, under what authority he could espouse the cause of Mr. Lokman Brothers, the locus of the appellant being wholly absent. There is no infirmity in finding the decision of the learned single judge in dismissing the writ petition on limited ground. 9. Before this court, learned counsel appearing for appellant has produced a photocopy of undated general power of attorney alleged to have registered on 15/1/2015. The authenticity of the said general power of attorney has been seriously objected to by so and so. It would be worthwhile to mention that a bare perusal of the photocopy of the general power of attorney produced by so and so, learned counsel appellant, do not appear to be a document registered before an appropriate registering authority as required under the law. In fact, the said power of attorney do not indicate as to on which date the same was executed. It would also be worthwhile to mention the power of attorney now produced before this court was not produced before the learned single judge. Kindly see that's the case. Now produced will not be accepted by the appellate court. Now see para 10. Be that as may, without expressing any opinion on the veracity and authenticity of the photocopy of general power of attorney, this court holds the appeal do not merit consideration. There is no gain. One gain saying writ petition filed by so on behalf of was absolutely without any authority, as the finding and the remain unassessable. So this is the case, my. Now you come up. with a power. Now, power of attorney act. My lordship, my lord is now showing something else. See the concept of the power of attorney. The concept of power of attorney under section 2 is a principal relation between principal and agent. Now, when an agent represents before the court on behalf of the principal, he comes as like a principal before the court. This is the section 2 of the power of attorney. That's the kindest thing. Yes.
Dr. Vice.
I'll just take a couple of minutes. I'll just take a couple of.
No, I'll just finish it up to judgment on power of attorney. On power of attorney, I'll give a judgment.
Like I said, we have seen the picture.
Yes.
I'll take just a couple of over there. I'll take 2 minutes, not.
Yes, yes. Power of attorney. Now, what about the judgment of the power of attorney? Now, there are 2 judgments on the power of attorney. One is 2016, PSCC page 296. One judgment I have shown by the Locus brothers, that your lordship has looked in. That is what is the agreed person, what is his locus, and how the court dealt with an authorized representative, and what is the difference between power of attorney in Locus. And and also Locus says that it is not an undated power of attorney, it has to be a registered power of attorney. Locus, your lordship has looked into your judgment. And when it was produced before the appellate court, the court said it would have been before the learned single judge. It was not there. Here is also same. Now kindly see the judgment of on power of attorney. Para 36. 2016 PSCC page 296. Paragraph 36. What I want to show here, my lord, before your lordship, I read the judgment here. Para 36 is related to what is the relationship between a principal and agent. What is relation of principal agent? Because when an agent comes to the court on behalf of the principal, he acts as if like a principal before the court. But the relief is not been granted to an agent as if the relief is granted to the principal. That is the concept of section 2 of the Power of Attorneys Act. I don't know trouble it is here in paragraph 36. The law relating to the power of attorney is governed by the provisions of Power of Attorney Act 1982. It is well settled therein that an agent acting under a power of attorney always acts as a general rule in the name of his principal. Any document executed or thing done by an agent on the strength of the power of attorney is effective as if executed or done in the name of the principal, that is by the principal himself. An agent therefore always acts on behalf of the principal and exercise only those powers which are given to him in the power of attorney by the principal. Any act or thing done by the agent on the strength of the power of attorney is therefore never construed and or treated to have been done by the agent in his personal capacity so as to create any right in his favor, but is always construed as having done by the principal himself. An agent therefore never gets any personal benefit of any nature. Applying the aforesaid principle, this court in Surah's Lamb, so and so, in paragraph 20, 30. So, the principle which has been laid down is that what is an agent and how he acts on behalf of the principal. What I want to draw your lordship attention to the R case is that it is neither a power of attorney which was given by the proprietor to Mr. Rajapal, who comes before a learned single judge and he projects himself as an authorized agent. Now, in the case of Lokman, says that authorized agent will not do. It has to be through a power of attorney, if at all, because authorized agent doesn't act as if like a principal, so far as the power of attorney act is concerned. Yes.
Now, the issue was it,
No, it was not taken up before the last. It is before the division bench, it is taken up by us, and we have looked into it before division bench, and this being absolutely law, because if this point, my lord, with great respect I am saying, my lord, if this point would have been taken before the learned single judge, my respectful submission would have been, the learned single judge would not have allowed the respondent to be present, to present his case. This is my humble submission. Because neither the learned single judge, my lord, my lord, my lord, by the statement of a lawyer, your lordship never asked us which paragraph. Your lordship believes us. Your lordship believes us. That is why your lordship says any statement made by us, there has to be truth in it. But suppose we say we mention in paragraph 8, your lordship said that they have mentioned, okay, there may be a truth. But once it comes to the notice that no, this statement is wrong, then your lordship will never trust. Maybe this particular point, my lord, the learned single judge was never pointed, neither it was not noticed by the learned single judge. This
was not raised by anyone.
we did not raise before the, no. It is only before division bench we have raised this point. Because when an appeal was filed by the appellant, by a proprietor, then we raised this point. Whether you have a locus, number one. Number two, whether you have an aggrieved person, because you are not before the learned single judge, representing the private respondent. Number three, you have only authorized. Number five, what authorization has got to do with a power of attorney? Authorization doesn't have any value in the eye of law. It is only to a power. I could very well understood that in Wakalatnama, it is by a power of attorney, which is given to an agent. It is not given. Kindly see, that is why before a division bench, we have brought that Wakalatnama which was filed by Rajapal, by an authorization. That's what the point. These are 5 points which we like to address your lordship on these 5 points. There's number, and also the power of attorney is not a registered document, which in Lokman says that it has to be registered. So this point, if your lordship considered all these 5 points, number one, power of attorney is neither registered, your lordship has seen, that will come last. It is a case where you did not have annexed any power of attorney before the learned single judge. One. Number two, it is only by way of an authorized letter, which it appears in last page, at page 431. 431. Your lordship will kindly mark that 431 of the appeal memo, where authorization letter was issued to represent the farm or legal matters. So what is the right of Rajapal to appear before the court by virtue of the authority letter? So our answer is that you don't have any authority to appear unless it is backed by a power of attorney, and that too it has to be registered, which has not been done in the instant case. It is only before a division bench you have shown that there is a power of attorney, and that too on a backdated 2024, somewhere in the month of December. And it is before a magistrate, even it is not a registered document. So all these 4 points, my lord, we have come up before this court by an appellate court that writ appeal is itself not maintainable. So that was the point why we filed this application regarding the maintainability of the writ petition. We forget, my lord, for a moment that there is a letter, there is an authority, there is a power of attorney, there is a document which is executed saying that never it was given to Rajapal to contest before a learned single judge. No power was given. Maybe we forget for a moment, but the fact remains On the face of it, if your lordship looks into record, appeal, the private respondent who appeared, it was not through a power of attorney, on the face of it. So on this ground itself, the appeal is not maintainable, one. Second, on merit of the case, even your lordship consider on the merit of the case. First, your lordship says that no, on the mentally point, he doesn't have a locus, he is not an aggrieved person. That's the end of the matter. So he cannot pursue this matter before an appellate court because he is not aggrieved by an order passed by a learned single judge. He has to be some relationship between a principal and agent. If there is no relationship, some agent has come, agent has not come also, authorized. No, nothing in the record, not is backed by any law. So if your lordship looks into the first point, that without going into merit of the case, we'll decide on the maintainability point, that's the end of the matter. Now let us say that maintainability, apart from maintainability, merit of the case, I want to sum up. Merit of the case concerned, I think the judgment that has been passed by a learned single judge, there is nothing to interfere with the judgment. There is no arbitrariness, there is no perversity in the judgment. Judicial review not only connects to malafide, it also related to arbitrariness or discrimination. Not only malafide, you have to see other 2-3 points. To what extent judicial review in a contractual matter? Law has evolved, developed. What we there earlier from 1979, your lordship knows, Ramanna Dayaram Shetty's case. Thereafter, Sri Lanka with the Express newspaper, Mahabir Auto, Tata Motors, all this, Michigan, all the judgment. Now there is something anti-agency. Then global, what is the judgment? The judgment Galaxy, all the judgment. Now there is one judgment of the Supreme Court. What I am saying, how it evolved and how it is developed. There is one judgment of the Supreme Court. What happens? Now that's the one question to be. I am putting giving an answer. Now they have progressed. They have progressed. Now your lordship may see public interest. Let them continue. Maybe an authorized repentant have come before the court. We are looking into the proprietor coming before the appellate court. We don't like to decide that particular issue. We don't like to interfere. They have done considerably this amount of work. Maybe 60%, 50%, we don't know. My client says that they have not done this amount of work. That's my instruction from my client. Now, if there is a contract and that been executed and they have been working, whether sitting before an appellate court, whether your lordship can interfere and set aside that particular contract agreement, maybe in the public interest, whether your lordship can do it or not. That's the question to be. I am putting myself, like giving an answer that there is a judgment of the Supreme Court which says yes, even then it has to be looked into legality and validity of the work in question, whether the decision-making process which they have rejected on these 3 grounds, whether legally they could have rejected. Now kindly see one judgment of the Supreme Court on this issue. 2024, 10 SCC page 273. Paragraph 37. Kindly see para 37. Lordship got it, para 37. 37. 37, last page. 37. The submission made by learned counsel for respondent that project in question being infrastructure project as also one of the mega project. So here is also a public interest mega projects. This court may not interfere more particular in view of the fact that agreement has already been entered in between the respondent BCCL and the special purpose vehicle of respondent number 8 cannot be accepted when we have found that the impugned decision of the respondent BCCL was grossly arbitrary, illegal, discriminatory, and violative of Article 14 of the Constitution of India. As held earlier, the government bodies, instrumentalities are expected to act in absolutely fair, reasonable, and transparent manner, particularly in awards of contract for mega project. Any element of arbitrariness or discrimination may lead to hampering of the entire project, which would not be in the public interest. This is something else it says now. Now, you have element of arbitrariness if it is found by your lordship that there is an element of arbitrariness and violation of Article 14. My lord, then, my lord, a person who is entitled should have been awarded with the work. Now kindly see 38. 38 paragraph is also important. In that view of the matter, impute decision of the respond number so and so, rejecting the technical beat of the appellant and further declaring respond number as successful bidder is set aside. Kindly see, my lord. Is set aside. Any action process undertaken or agreement entered in person of said decision also stands set aside. It shall be open to initiate fresh tender for the project and to proceed the same in question in accordance with law. What the learned single judge has said, my lord? Can you recollect in the last paragraph of the learned single judge judgment?
Cited that day.
I'm sorry, this was not cited. This is a law point, my lord. I can cite any moment before this court, my lord.
Okay.
Yes, these are not cited. Your lordship is putting a question that whether it's cited, it is not being cited.
Because the language is quite similar in the judgment of the learned single judge.
Yes.
This part.
Yes. No, but learned single judge.
The lines are not legible. That's why I was finding it difficult to find out that.
Which one?
37.
437 of the judgment.
This.
This, I don't.
27 was not legible.
I'll put it.
It's okay.
Sorry, my lord. Absolutely.
So somehow we can now make it out. One thing West 57.
My lord, will kindly see this.
It's okay.
No, one.
It's okay.
Please, my lord, your lord.
Once you read it, so we should.
No, please, one, your lordship can read this. My particular, please, I have marked it in bold. Your lordship will kindly see that. I'm sorry, kindly see that.
Okay.
Kindly see, my lord. I'm sorry, I have marked with.
I found some pages were missing. After 36. 37 was missing.
Okay. Oh, my lord, if you see, now, my lord will kindly see, if you see the judgment of the last paragraph of the learned single judge, the court has never said it should be given to me. Kindly see what it says. 395, kindly see, my lord. If the learned single judge we have brought notice to the court that this is not been signed, but someone where power of attorney was not given, somebody has come to the court who doesn't have any authority to represent, then the matter would have been taken very seriously, my lord. 395.
I think what
395, yes.
says remaining part of the work.
No, only not that. The remaining part of the work is to be assessed, and the same is required to be allotted to L1 bidder who is found eligible. My lord, the word eligible. If I am not found eligible in accordance with law, it is to make clear. So far, the work done by respondent, if I'm in the meantime is concerned, there will be no restriction toward payment and release of the bill to the respondent number 5. Maybe.
That's what.
Yes.
What directors to allow the work.
Yes. No, it is not who is found, my lord, who is found eligible. Who is found eligible. You make an assessment. Kindly see the remaining part of the work is to be assessed. What is the amount of work he has carried? Maybe he has carried 40% of the work. Remaining part is to be assessed, and thereafter same is required to be allotted to L1 bidder who is found eligible.
So that you don't perform double work, that's all.
Yes.
Remaining balance work, whatever there,
Yes.
assess
Yes.
and give it to the L1.
Yes.
Found to be eligible.
Yes. Now,
The balance to be paid, the number 5 is not in there. Whatever that he has done,
yes.
that's it.
Yes. Yes, that's all. Now, my lord, the question here, there may be 2-3 questions which may trouble the court also. That is a public interest. So in the midst of this appeal, now my learned friend said that I have executed some portion of the work. Maybe 10%, 20%, 30%, 40%, I don't know, my lord, 40%. Whether at this stage, being a mega project, whether your lordship like to interfere? Because this is a public interest project. Why? We should not go into it. But that is not why I am showing the judgment of this week. Even then, if your lordship find A is a discrimination, there's an arbitrariness in awarding, in not considering my case under Article 14. So definitely your lordship can interfere. This is what the judgment says, my. And the agreement was set aside. Kindly see the contract which was entered between the party, in this case, Bangsidhar, my lord, that was set aside. That was set aside. Even then today, if a lordship finds that my case should have been considered on merit, my lord, then even then it can be set aside. Maybe he has done 70% of the work. What is there in doing 70%?
This case that was not set aside.
Which one, my lord?
No,
Yes,
not set aside.
I have not followed.
Agreement is not set aside.
No, it's not been set
It's
aside.
implied.
There is implied because remaining portion of the work implied. And my lord will kindly see.
Yes.
Now, only, but I think I have, your lordship, I am grateful that your lordship has given a patient hearing. Is only the affidavit stand of the government, my lord will kindly see. Last I was going to show it because I have not found one thing, my lord. The affidavit which is filed by my learned friend's client for learned single judge, I have not find any single line where they said that a power of attorney was executed. Nothing. It is only authorized letter.
Authorization.
From page 422, I read up to 430. Not a single line I have read that a power of attorney was executed. It was registered, such and such date. Nothing is there. Only authorization letter. And thirdly, kindly see the affidavit of the government. See page 400, my lord. See the affidavit of the government. 398 it starts. 396 it starts. Now kindly see why the learned single judge has said that you want to improve your case by filing an affidavit. It is not allowed because a public order which has been displayed and you have taken a different step. See 400 para point 4. Para 400?
Paragraph 8.4.
8.4, correct. 8.4. The petitioner furnished 3 major ongoing projects but failed to furnish the detail of key tools and plan and technical plans deployed against respective project. This is one of the 10.
This is not traceable to any of the.
I have not found. That is what I am saying, my lord. It is not traceable to any of the rejection order that has been passed. That's and they have to, my lord, they have to cite a reason for what reason your particular is rejected. They want to, my lord, nothing wrong by the learned single judge in bringing Mohinder Singh Gill case. So I think, my lord, this is the case. I think there is no, should not be interfered. The order passed by the learned single judge, my lord. I think nothing wrong by the learned. And in Mohinder Singh Gill judgment is required that we have got the judgment. The lordship will only keep this paragraph 8, which has been referred by the learned single judge. The Mohinder Singh Gill judgment. So, paragraph 8, man. Paragraph Mohinder. I think, my lord, I'm deeply obliged, my lord.
You can take back this, the other one.
Yes.
I can somehow make it. 24 wasn't there.
Your lordship will keep this.
Government,
Yes.
we hear the government also.
Yes.
May I please? So, my lord, I'll come straight to paragraph 21 of the judgment. So one of the reason of the judgment was that in the rejection order, there is no reason was not given. Clause itself in the SBD, clause 4.1, 4.b, what is it that is already explained in the SBD. So no detailed reason need not be given. In every tender so far, as per my knowledge, in every rejection or every acceptance, only clause is given. No detailed reason is given. So this finding is against the SBD. Since for what 4.7 says, what 4.b A says, it is already given in the SBD. So reason is already there.
So one thing, were you required to produce the records for the single judge?
Report was not called for it.
Not for.
And my lord, then regarding participation of 3-4 packages, my senior has he has read out some portion of this 4.4C. To qualify for a package of contract made up of these and other contract for which bids are invited in the notice inviting tender, bidder must demonstrate having experience and resource sufficient to meet the aggregate of qualifying criteria for individual contracts. Individual contracts. So every work package he has to demonstrate.
So where are you reading that?
That is page 65.
Read.
Read affiliates. 4.46 and 4.4C. C.
Qualify for the package.
Yes, yes. Individual package, he has to demonstrate that he has sufficient manpower and machineries. Even in the page 6,
4.4 was not quoted.
it's not quoted,
Not quoted.
but as per the, and page 60 also, serial number 11. Bidder may participate in 3 or 4, that is, there is no bar, but he has to demonstrate in individual contract. He has
You have to demonstrate.
demonstrate experience or resource, sufficient resource in individual package, individual contracts. Serial number 11 is also mentioned. Since he have raised that there is no such conditions, so there is condition.
Must demonstrate having experience and resources sufficient to meet the aggregate of qualified.
For individual contract. And regarding my lord,
How we measure this availability of construction was technical person. So
my lord, since
how did they demonstrate? How does one demonstrate?
suppose if,
By giving the list of manpower, list of machineries at their disposal.
suppose he participate 3 or 4 packages, he has to demonstrate that this machinery I am going to use this in this package, or since if he furnish ongoing project also, this machinery and men and machinery is being used in this package, project, ongoing project, and this set of men and machinery is going to deploy in this package if contract is about. That has to be furnished.
Okay, the set of machinery, manpower, and all that,
Yeah.
multiplied by 3.
Yes.
If three tenders have been responded to, He should have that for each of the tender.
That was the committee has, as per the committee, that should be. But I'm not.
So it so happens that there are so many, there are a lot of tenders floated.
Yes.
A contractor may respond to 10 tenders, then what happens? He'll need to have 10 sets everywhere.
That is not possible, my lord. Otherwise, then the contract, it will not possible for any individual contractor to execute. That is not possible. Otherwise, my lord, judgment in our affidavit, we have clearly, specifically alleged that invoice which he have submitted is not genuine. That our affidavit allegation has not been replied by the petitioner and the present respondent by filing affidavits.
But that is also not the ground of your rejection.
Yes, that is also 4.7 is also, that is also ground of the rejection.
It's covered by 4.7.
Yes, furnishing misleading or false statement in information.
Okay.
That covers. So the petitioner has not replied by filing an affidavit, by swearing affidavit. Verbally, they denied during the course of argument. Then regarding L1s, during the course of argument, the petitioner stated that he is the L1. L1 can be, my lord, determined. It is auto-generated L1, not by, if he furnish, suppose 42 rupees, suppose someone furnish 43 rupees, he cannot say that he is the L1. It has to be auto-generated. The BOK has to be assessed. So that
comparative statement is not there.
is,
L1 who's L2.
yes, since he is not qualified for in technical bids,
After technical, one will go to financial.
financial, his financial bid was not assessed.
After technical and financial bids are complete, then
What?
the comparative statement.
After technical bids, then financial, those who qualified in technical bids, their financial bid will be open. So his financial bid was not open. How he can say that he is L1?
So at what stage is that determined? L1 and L2? At what
That is financial.
after finance?
Yes,
Not before that.
not before that. So since his bid was rejected at the stage of technical, so now he cannot claim that he was the L1. Then now the difficulties with the department is that,
Come to judgment again.
yes, judgment,
Last para, second last para.
yes, in view of the fact consequently, action including the issues a letter of intent work favor of the respondent by stand interfere with accordingly set aside. The remaining part of work is to assess, and same is required to be allotted to L1 bidder who is found eligible in accordance with law.
So it does not say that it should be the petitioner.
Yes,
It's
but
L1.
it is not specifically mentioned, but on queries, he said he is the L1 during the course of argument.
Supposing there is no appeal and you proceed as per this, then you determine L1. It can be anybody, isn't it?
Now, my lords, now the difficulty is now this financial determination cannot be made at this stage. That is the issue. Since it's auto-generated and it's a e-tender,
But this is not your appeal.
this is not my, this is the difficulty.
So you say that we cannot do L1 now because everything is auto-generated and that time has lapsed.
Yes,
Now it's not possible to go back in time and find out who's L1.
that is our difficulty. Yes. No. As per my, we have already given to the authority. The government, they have already processed the file for appealing, filing appeals. That this whole process needs law betting and all these things. That's time consuming.
So it's in the card.
Yeah.
Appeal.
Then, my lord, during the
But as on today, there is no appeal.
no appeal. During the course of, there also, the single judge also said that since there is not substantial work has been already not yet executed, since the submissions of the petitioner was only at the best 30% work was completed during the time of argument. But after filing of this writ appeal, there was order direction from this Honorable Court to have a constituted committee to verify how much work has been executed. So the 3-member committee was constituted. They have inspected the site. As on 30th June 2025, 59.5% work was already completed. Now it's 2 months. Now as per my latest verbal instruction is that formation cutting completed, then drainage, then GSB, culverts, all this work now, BMW and BT, that part is remain. And I'm told that bill for that already executed part work bill is also submitted. BMW is, that is before black topping, they have to again put some.
It's not that car company.
Not car company.
The other one,
Other one, BT is black, black carpeting. So, this judgment is not interfered, my lord. Since work is in the verge of completion, so public interest involved here in this case.
how much you said? How many percentage was the percentage?
Percentage, I'm not told the percentage, but component of the work they've completed. Formation cutting already completed. Then drainage, around 70 or more than 70.
You don't have instruction. Don't submit.
The percentage I have no instruction only.
Because we got the
One
report.
written document is there.
Uh.
On 3rd of July 2025, your lordships have passed an order. In this case, based on a report called for by the school, by the chief engineer, 59.79 as on 3/7/2025. 0.79 as on 3/7/2025. This one order is there. 3/7/2025. On that day, on the basis of the report submitted by the chief engineer as called for by this one report, this one report is recorded at 59.79% as on 3/7/2025. I'm talking about the percentage. You're asking about percentage.
No, yes, black topping now is remaining. So, my lord, my humble prayer is that this judgment of single letter, single judge need to be interfered with.
Need to be interfered.
This is set aside judgment.
Not interfered.
No need.
Need to be interfered.
Since now I am, although I am in this side, I have to defend the government. That is the difficult decision is of government.
Mr. Kitara.
Jitara, yes. This is my suggestion.
Right?
Just 5 minutes time. They have taken more than my last. I want just 5 minutes. Not more than that. Yes, I'll complete. Lordship may state your turn to page 400. I'll just show 2 things in response to my 400. This is part of the affidavit filed by the government before the single judge matter. There, the question was raised that government didn't argue that there were 3 projects. For 3 projects, we have submitted one set of documents. Government has taken a pre-matter. You will find it page 400. That's just above the paragraph 9 at the bottom matter. The petitioner furnished 3 major ongoing projects but failed to furnish the details of key tools and plan and technical personnel deployed against respective projects. Language is like so for 3 different projects, 3 sets of documents were not filed. One set of documents demonstrating one set of key personnel and one set of key equipment and machinery. This I am responding to the question raised by the respondent that the government did not take it. Government has taken the effect. This is my first submission. Then Lordship may kindly turn to page 382. 382 is a part of the judgment itself, my lord. Paragraph 9 at the bottom, my lord. Line number 4 from top. He has submitted that it is a matter of fact that on 2/24, a technical evaluation was done for 3 packages wherein the same list of machineries and same list of technical persons were verified. And along with this, I'll make one submission, madam. Point has been raised. Let's see. Subsequently, in the month of October 2024, when I submitted a tender, a bid in response to an NIT, this set of documents were accepted. Earlier, you rejected in this case, but subsequently, when I submitted same set of documents in response to a different NIT, same set of documents were accepted. Question is not about acceptance. Question is about, my lord, the fulfillment of the terms and conditions of the NIT. In the subsequent NIT of October, when it was accepted, that bid was submitted in response to an NIT for one package. One set of documents for one package will have to be accepted. Here, it was rejected because for 3 packages, you have submitted one set of documents, meaning thereby that one set of technical person, one set of equipment. And that is why that ground mentioned, that is the ground on which you did not fulfill the requirement to demonstrate you have technical person and you have got key. And my learned friend, government, my lord, has rightly pointed out at page 60 and also at page 63 that for individual contract, you have to show that you have got the key equipment, etc. Clause itself is there. If that clause is read along with the clauses mentioned in the rejection letter, my lord, it is apparent that for each package, you have to show separate set of equipment. As your lordships have rightly pointed out, one company, one contractor cannot have 100 sets of documents, equipment. But the fact remains that if you are responding to a NIT for 3 different packages at a time, and on the same day, the 3 packages are evaluated, and it is found that for with same set of documents you are trying to fulfill the requirement of 3 packages, naturally they have to reject, which they have done. It is humanly not possible to execute work in respect of 3 packages when all the 3 packages bid was opened on the same day and work will have to be continued simultaneously. It is not possible. There is my second submission, my lord. And my lord, about this is on merit, my lord. Nothing high. There's no other point. As far as the point on the question of power only concerned, my lord, the judgment has been judgment on which reliance has been placed of 2015. That was in a completely different context. If your lordship goes to paragraph 3 of the judgment, what will find of the judgment of 2015 5 here, where the different bench of the court relied on by them. That is on the question of locus to file a writ petition. And there, paragraph 3, if your lordship goes, that was completely a different issue. 15.5 here. Can you see this paragraph 3 that will make it? Paragraph 3. The context in which the judgment was delivered. By the said undated, first of all, there is no date, undated authorization letter, the appellant was only authorized to collect, receive, and submit tender documents on behalf of so-and-so. In the course of hearing before the learned single judge, Mr. So-and-so, seriously questioned his locus standi of the appellant, the locus standi of the appellant, submitting that the appellant is not an agreed person and no power of attorney having been issued by Mr. So-and-so. In our case, my lord, although before the single judge it was not filed, but subsequently in response to a point raised in the IA when we have submitted the power of attorney, my lord, which was executed before the executive magistrate, and there is no further reply refuting that or disputing that power of attorney. That was power of attorney was of 2024 before the writ petition was filed. It is another thing that before the single judge, my lord, no question was raised, so that power of attorney was not produced. And on top of all, my lord, when the proprietor is not saying that I did not contest the writ petition filed by you, has the power of attorney, has the proprietor till now before your lordship projected before your lordship that see, I did not contest the writ petition. I got the work order and there was a challenge and I didn't want to contest the writ petition. Is he saying, is there any material to show that the proprietor of the appellant in whose favor the work order was issued did not want to challenge or contest the writ petition filed by the respondent? Till now there is no way. In between they have procured one document that too under what circumstances I have filed an affidavit, and the proprietor has responded to that IA saying that I have filed the writ petition. Just one paragraph in the IA. Just one paragraph. That means one paragraph. In the counter to the IA, para 4 at page 18. Para 4, the deponent states that after the writ petition filed by the applicant was allowed by the learned single judge, considering the fact that pursuant to the letter of intent and the work order issued in favor of all party, about 65% progress was already made in execution of the work, and the work permission cutting was almost over, and a huge amount of investment was made in the same level of work. Raj Pao, this affidavit was shown by the proprietor himself. There is no dispute. He is saying that Raj Pao, the constituted attorney of the proprietor, broke some sharing, and the proprietor himself collectively decided to file the instant appeal against the judgment and order passed by the single judge. Accordingly, said constituted attorney took all steps necessary to file the instant appeal. However, since the cause in the cause title of the memo of appeal to firm, namely measures sending construction, was stated to be by the proprietor, along with the memo of appeal, a Vakaratnama power duly executed by the proprietor, which was lying in the file, was filed in order to empower the counsel to file the appeal. It is pertinent to mention here that in the writ proceeding of the case before the single judge, the affidavit of opposition filed on behalf of the number 5 hearing was shown by Raj Pao, the constituted attorney of the proprietor. Proprietor is making this statement that I contested the writ petition. My writ petition was contested by filing an affidavit in opposition by my attorney, who is Raj Pao. And the power of attorney, which I have subsequently produced, is of 2/12/2024, which you lot will find in the with my additional.
Okay, Mr. Mazumdar.
Yeah,
We'll consider.
my that's my submission. Chief Engineer submitted the report on 1st of July 2025. Based on that, your lordship passed the order on 3rd July. That 59.59% work was completed as on 3rd July. Thereafter, work is continuing.
Is right. You have to reserve the judgment.
My
Senior counsel assistant.
Takar,
Bagan.
Takar,
Bagan. Counsel. For the appellant, also had Mr. Digan Prakash, done at senior counsel. Prime Minister, are the respondent number one. Also, Mr. Tarak. Mr. Tarak, you are the what? Senior governor.
No, standing council RWD, standing council.
Tarak, standing council, RWD. For respondent numbers 1 to 4.
2 to 5.
2 to 5. What else? No. So, hearing.
Keep coverage. And only one thing I wanted to say when I forgot, madam, regarding the registration of power of attorney. A power of attorney under section 17 of the Registration Act is not required to be registered. It doesn't fall in any of the categories of the document mentioned. Section 17.
But that's why I said he will not end up.
I have
My
completed
lord,
in 5 minutes.
He will always say 2 minutes I will complete. I always see the word. He's never see now again he started saying
On
something.
the lighter vein, being my elder brother, I have not able to complete.
No, you can't.
Item number 6.
There is lordships are now thinking of it sitting singly. There is a appeal under against a conviction under POXO. I came prepared actually. The man is in. Why not? Why be difficult? Yes. So about like the
Something to do with notice. I saw somewhere that notice was to be sent to the complainant.
complaint.
Yeah. And what has happened to
It is
that?
completed, man.
Completed.
I'm appearing, Lord.
You're for
I'm
the
appearing.
complainant.
Yes.
Stop with these bench matter.
6. Item number 6.
It was for service, my lord. The service, answer notice has been received, your lordship, from the process server of this legal aid council from the concerned district, my lord, the Assam.
So notice to
Yes, ma'am.
Why?
Why, your lordship? Here, your lordship, the allegation, the accused is convicted for committing murder of his own daughter, my lord. Yes, my lord. And the wife is the informant, your lordship, here. Informant victim, your lordship, that expect has been considered by this honorable court regarding on the relying on the your lordship the Jagdish matter. So it was in fact the last effort has been made by this court to serve the notice to the victim through process server of the district legal aid council of the Assam. Your lordship, yes, your lordship. POXO yes, Deepak Nayak case is clear, but your lordship, so far as the general law is concerned, general procedure is concerned, my lord, the Jagdish matter, basing on the Jagdish matter, the unbridled participatory right has been recognized. So just considering that aspect, the notice, without your lordship issuing notice to the victim family or the victim, your lordship, this will be difficult to your lordship the exercise its participatory right. On that aspect only, your lordship, the notice was issued. However, your lordship will find the order of this honorable court in your lordship 23/1/2025, my lord. There, your lordship, there was one finding of this honorable court, and wherein your lordship the Jagdish Singh matter was also referred. However, your lordship, liberty has been given to the amicus to make a prayer for appointment of amicus for the victim side. Your lordship will find the same the observation in dated 23rd, 1st, 25, my lord.
the appeal is filed by the accused.
It's a
Father.
it's a jail appeal, my lord.
Correct.
Yes.
So, it's filed from jail.
Yes, my lord. Yes.
Father of the deceased.
Yes, your lordship.
There, you are a victim.
Yes, my lord.
Now, there's nobody on behalf of the
Victim.
victim.
Yes, your lordship. Yes. Yes, your lordship. See. Lordship, she was not found there, Your Lordship. It's reflected in the display mark there, madam.
This code might follow dated 7/5/5.
Three weeks, madam. Yes, Your Lordship. Since Your Lordship, it's a 302 matter. So in light of the Anokilal judgment, Your Lordship, the 10 years or above, council having 10 years or above practice may be appointed. Am I-
I think that thing.
Yes, Your Lordship.
That's why it's come before DB.
Yes, my lord, but in the list, in the legal aid council, perhaps there are some council who do not have more than 10 years of practice. Anyways, Your Lordship, your confidence. Yes, yes. Oblige.
Item number 7.
But your name is not. Been appearing earlier. Now you're not appearing. I will inform them under name also. They will inform. I will inform. Starts like here, Lanet Council for the Lanet Council, something that you don't know where it is. That we have to take the name of it.
Item number 10.
Have you been permitted to bring anything on the court? It's the first time.
Page number, maybe, I don't know. The para number 11. Wait, wait, wait. They, kind of make so many marks they have paid.
What you want to bring on the court? Why did I? What is that document of what clause you want?
This, this but other dated 0804. Page number 7. The last but honorable court has honorable last court has clearly made make the instruction. It is possible to prevent government download of the being on the network agent. And the result of the game like create a concept of getting out of the page. Yeah, that is so that they buy both by the way of it's quite a lot of part of the thing of the process.
Again, you're reading the same old paragraph.
So this is the electricity page number 12. Thing on the recording very report.
The petitioner
Yes, madam.
to the PIL.
Yes, madam.
What is the PIL regarding?
One AL is regarding the construction of community hall. Community hall at 12 different places. Where my PL was now that the main point here. It from one place to another place, wherein cannot be done in the approval of finance department, planning department. That was my challenge. And it was involved around 11 crore each day. They are doing their free sale. It's not for the lab. And that's what I'm being the sort of inquiry was that kind of existing inquiry they have not done for that one.
So against the PIL, has anything been filed? Affidavit has been filed?
My lord, from yes, from the Secretary Planning and my lord in this man, my lord,
Has it
Every-
been filed?
not yet filed, my lord. I've just received a letter, my lord, asking for some more time to file that.
Okay, what do you say about the IA?
IA, my lord, he has filed the IA, my lord, saying that he will be editing some more documents, man. So what sort of document he was to produce, my lord, only he can say, my lord.
No, he is the next NXFP.
Connectivity.
He wants to incorporate NXFP to the PIL. Any objection from your side? Only NXFP.
My lord, no issue, my lord, no, I don't have any objection. my lord.
Start, mister. Mr. Nebo. But Mr. M. Nebo, learned counsel for the applicant, stroke petitioner, submits that by filing his application, the applicant seeks to incorporate, seeks to bring on record the order dated 13/3/2025, issued by the Deputy Commissioner, Kurung Kumei District, Moloria. Since the same is material for considering the connected PIL filed by the applicant. Filed by an IA also.
My lord, it was the report that they are proposed to give by the government. But yes, it was only long,
Okay, in view of above, the petitioner is allowed to file an additional affidavit incorporating the order dated 13 March 2025. Connected PIL. You file one additional affidavit, incorporate this, read that PIL. The IA will be disposed of. List again after. No. Disposed of. Then in the main PIL,
NPL value will be returned for more time to file affidavit.
anyway, today only IA is listed, isn't it?
Yes.
We are not required to pass any order. Yes, next item.
Item number 11.
Yes, Mr. Kandu,
My lord.
you are the appellant.
Yes, my lord.
What is the matter?
My lord, this is my matter, my lord. It is, my lord, land, the earlier, my lord, the around 11, 1,43,000 around, my lord, area was allotted to the BRTF, my lord, by the government of Arunachal. But later on, my lord, after having allotment, my lord, after giving allotment to the BRTF, my lord, it was found that they are in access possession what they have been allotted officially. Therefore, after conducting ground verification, my lord, they have found that around 10,000 area they are in access possession, my lord, that BRTF. In that regard, my lord, those access in possession of the land, but access land, this was allotted in favor of the appellant, my lord, after following due process of law, my lord. Thereafter, my lord, what happened is, since that physical possession, there was a certain obstruction from the BRTF, my lord. Then subsequently, we approached we filed a representation to the authority concerned to make clearance, my lord. And it was not considered. Then subsequently, we approached this honorable single bench in earlier round of litigation, and in which it was directed to complete a verification ground
why this clearance has not been despite of the allotment.
You were the petitioner.
Yes, Mala, I was just a brief, just short brief. I just
No, you were the petitioner in the writ petition.
yes, earlier.
Your
Then-
petition was dismissed.
No, not dismissed, but this is first round of litigation, first round of writ petition. But the London single bench is directed to complete the ground verification, and accordingly, in terms of the earlier the direction of the honorable single bench, madam, verification was carried out, madam. Wherein in the verification they have admitted the authority, the respondent authority, they have admitted that these earlier allotment given to the BRT, madam, is consists of two plot, madam, plot 1, plot 2. They have admitted although they have carried out the verification in respect of plot 1, but in allotment order, it is not mentioned as to how much area falls under plot 1 and plot 2. Then they have admitted that in plot 1, they have conducted verification wherein 1,000 area found to be variance. They are found to be excess, but they have admitted that plot number 1 and number 2, they could not conduct because of the lack of equipment. That was their finding in the report. But arbitrarily in the finding, but despite of these recorded mallet, the ground fact, they have said that there appears to be a double allotment, overlapping allotment. Now, this fact, then
See, Mr. Kamdu, see, your appeal is against the order.
yes, sir. But this is just highlight, mallet.
No, please listen to me first. Your appeal is against the order dated 25/6/25.
Yes, ma'am. Yes, mallet.
Passed in WPC 1-2.
Yes, mallet.
Now, your writ petition was dismissed,
Yes,
correct?
yes.
Because court found that there's some disputed questions of fact.
Not that. But there's the court finding was that
No, you come to paragraph 40. Moreover, such disputes has been raised in this petition cannot be ascertained
that
in
is
a
why.
writ proceeding. That is why the court said that there are disputed questions of
Yes,
fact
Mallet,
and writ petition cannot be entertained. Why do you say no?
that is why, Mallet,
This is what is written in the judgment.
Mallet, that part, Mallet, I'm coming, Mallet. That's why, Mallet, so far, disputed fact, Mallet, we are not asking that, only the prayer was to conduct the verification, Mallet. That was the, in terms of earlier also, Mallet, earlier direction also, our request was, Mallet, let the verification be done if really, because that is the authority, Mallet, it's within the allotted area, within the disposal of the government, Mallet. If anything, on verification, because plot number 2 that has not been verified, that has been no ground verification. Only our grievances is let this ground verification be done by the authority, because they are giving that plot number 1. They have the plot number 2. They are not touching, Malab. There no verification has been done despite of the direction, Malab. That is only our. If it is not, there's no excess allotment, there's no excess possession in the BRT by the BRT, but there are no cases, Malab. Only my respectful submission, let there have a physical verification done in totality, Malab. Because in the record, Malab, in the writ proceeding, Malab, I'll show, Malab.
Despite dismissal of your writ petition, you still want that verification to be done.
Yes, Malab. But why is this required, Malab? I'll just show in the pleading itself, in the record, in the writ petition, Malab. That part has not been considered by the London single bench, Malab. First thing, Malab, they have admitted, this is admitted on part of the respondent, categorically they have admitted that the plot number 2 has never been, they have never, could not verify because of lack of equipment. Malab, that cannot be ground, they have admitted. And apart from that, Malab, they have, apart from this admission, the BRTF, who is respondent number 5 in the writ petition, they have brought on record in the affidavit, wherein in their affidavit in opposition, the document relied, the sketch map, they are showing that their excess possession of land, what they have been allotted, Malab. Despite of these fact, Malab, this aspect has not been considered. And our only prayer is that let this, the plot number 2 be verified, ground verification be done by the authority. And if there's an access, because the official allotment has been given to us and we have been paying our revenue, Malab. That, but if Malab.
We are a bit short of time.
Malab.
We have to sit separately again.
Malab, tagum, Malab. Tabat, no, come to, Malab. Tagum, tabat, tagum, ti tagum, Malab.
Sorry.
Bye-bye.
Okay. This matter again. Hearing on 16.
Deeply.
These methods pertain to the RT department. Earlier, the officer, Mr. D. Picha, he was conducting this methods. He has suffered the brain stroke. So,
He suffered
yes, yes.
what?
Brain stroke.
Brain stroke.
Yes. Mr. Picha.
I see.
So, can these methods be fixed on 23rd,
14.
20 and 20?
But why is it listed today for orders?
My lord, orders, I have to get the briefs also.
You want it on which date?
25. Item 20 and 21 has come on transfer. This item 14, I have to take the report.
Item 14, 20, and 21. One thing, we'll pass the orders as and when the matter reaches. I just want to see why this is. Okay.
May I listen?
Yes.
I make to maintain item number 11.
11, yes. What do you want?
After weeks,
You're for?
petitioners on behalf of Titapa.
On a prayer made on behalf of Mr. P. Tapak, one and counsel for the petitioner. Matter stands at 20. Yes.
Yeah, that's it. I make to mention item number 24, let's say, on behalf of B. Pathan, let's say. Due to some difficulties, he couldn't appear today, let's say. Matter will be fixed after B. Pathan. B. Pathan.
This for hearing, isn't it?
Yes.
Now, Mr. Tapak, stands adjourned for
After 2
weeks.
My lord, I may petitioners. I, on the behalf of Etatex, beg to mention item number 9. And my lord said conducting counsel is out of station due to domestic problem. Beside that, my lord, I have taken consent from opposite party. So my lord, this matter may be fixed after 2 weeks.
You're for the petitioner.
Yes, yes, my lord.
Mr. A. Tatak, one and counsel for the petitioner, said you have some person on a prayer made on his behalf and not objected. Stands adjourned for weeks.
Master.
My lord, I like to mention item 5. I'm appearing on behalf of Jumga Karpat,
Item number
5 ends. Relating counsel out of station.
on behalf of,
Jumga Karpat, also petitioner.
yes, what do you want?
Yes, Lord, sir.
What do you want?
Yes, sir. I make 2 weeks.
What do you want adjournment?
Yes, sir. Conducting counsel out of station.
Karbak is out of station.
Yes.
Okay, Mr. J. Karbak, learned counsel for the petitioner, is out of station.
Your lordship, there is interim.
On a claim on his behalf, matter stands adjourned. Interim order passed earlier shall continue with the negative list.
Bacho.
My lordship, I want to mention item number 25. Since my living council is out of emergency for village due to owning of the death of his brother. So this item may be listed for after 3 weeks.
Station.
Neelam Taji, leading council.
Okay, Mr. N. Tajel and a counsel for the petitioner. Same to be out of station. Mention made on his behalf. Matter stands adjourned for 3 weeks. Yes. For the petitioner, what is your good name? Why do you want to join?
By which my suspension was further extended to 1 days. There have been orders passed which are further extended by inspection. I think one of the orders being therefore I have to take instruction from
Mr. R.L. Mungon, learned counsel for the petitioner, submits that there are certain developments in the matter and for which he needs to take further instructions from his client. Stop aspect no, the matter stands adjourned for 2 weeks. Item 8.
May I, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 7.
Yes.
I have already taken the consent for the petitioner's application. May it be after 3 weeks, Your Lordship.
You gain housing.
Yes,
You're for housing.
yes, Your Lordship.
Why do you want adjournment?
I'm not prepared, Your Lordship.
Mr. Y. Rira, learned standing counsel, UD and housing.
Government Advocate.
Oh, learned government advocate submits that he needs some more time to prepare the matter. And stop the same prayer is not objected to by Mr. C. Body, learned counsel for the petition. You have come, this matter again after 2 weeks.
Wait, item number 13, I received copy of the affidavit opposition. I'll file a reply, I do adjournment for 2 weeks,
Why is it listed for orders? Mr. T. Som, learned counsel for the petitioners, submits that he has received a copy of the counter affidavit and requires 2 weeks' time for the adjournment affidavit. Where is the law?
Much.
And Your Lordship, item number 12.
Huh?
Item number 12.
Item number 2.
12.
12.
Yes,
What do you want?
Your Lordship. Here, we'll be filing our affidavit today, Your Lordship. So they fix after.
So while Ram, learned government advocate, submits that he'll be filing the counter affidavit of the respondents he represents within the course of the day.
Yes,
Stopping here for now, this is the matter again after a week.
operation.
Madam, may I made mention item number, Madam, 19. I've taken the consent of the counsel for the private respondent also, Madam. And polyamorous, Madam, the reply has been filed yesterday, Madam. And I just wanted to go through, Madam. Therefore, Madam, is consented by the other party, Madam. Better maybe fixed on 23rd of this month.
My lord, I have not given any consent, I'm sorry. Maybe I have not given any because, my lord, there is an interim or this NIT matter, my lord. So that the NIT has been suspended, my lord. Can I just ask, my lord, can there be a little bit modification of that interim order, my lord? Let us complete the process, but we will not issue the work orders, my lord. So entire process has been suspended.
Let the matter be called then. I'll see the file first.
Now, in that case, Madam, I need to file affidavit, Madam. For that, he has to file affidavit, Madam.
Malo, we have filed the affidavit long time,
No, Madam. Modifications, interim of the modification of the interim order, Madam. At least, Madam. Madam, if such matter is so urgent, Madam.
See, I'm not saying anything. I'm just saying that let me see the file.
See, Madam,
Let the matter be called.
Madam.
We'll consider.
Yes.
I'll consider your submission. Any other mention?
Item number 10.
Yes.
Otherwise, all of the pleadings are completed. Let this matter be taken about 25th.
Who's for the other side? Government. 25th?
Yes.
Who Would you like to have it on Wednesday or Friday? When it is again, supposing there's a division bench, then the problem.
Before 24.
Mr. B. Kaushik, Learned Counsel appears for the petitioner. Mr. Y. D. Ram, Learned Government Advocate, appears for the state. And they submit that the pleadings are complete and the matter can be taken up for admission hearing. As agreed to by the parties, this is the matter on 24th of September for admission hearing. Yes, sir.
Item number 1.
Yes, what is this one?
This is denied promotion. Madam, this is not madam. May I pray that madam, notice may be issued, madam.
Let us know what is the matter.
Madam, I am serving as madam.
You are in a hurry.
Yeah, madam. I am serving in the department as madam, trained graduate teacher, madam. And was appointed in the year, madam, 2006. 2006, madam.
Yes, what is your grievance?
My grievance is, madam, the department is not giving the promotions to us. Whereas, madam, the juniors to us has already been promoted to the post of madam.
Trained graduate teacher.
Trained graduate teacher. Earlier,
Where are you working?
madam, I am working in the department of elementary education and the respondent number, madam, 3, madam. Respondent number 3 and respondent number 4, madam. I was appointed in the year 2002.
No, where are you teaching? Which school?
Madam, I am presently attached with the madam, the office of the madam, the respondent number 4 and 5. Sorry, 3 and 4.
3 and 4.
Yes.
Director of Elementary
Yes.
Education. You are attached there. You're not
Yes.
teaching.
No longer I am teaching for last madam, several years, madam.
No, in the directorate, what do you teach?
No, madam, just I am doing the official work, madam, in the establishment.
Exactly. You are not teaching now.
No, not teaching now. But my designation, madam, substantial post.
DGT. Graduate teacher.
Time.
What is your grievance?
My grievance is, madam, I am serving in the department for the last 20 years, madam, without any promotions. Whereas my juniors are being promoted to the post of madam, district adult education officer.
Okay, for that reason, there has to be vacancy. There has to be
There is a vacancy, madam.
There has to be some avenue for promotion. What is your avenue? You cannot just be picked up and promoted. You tell us.
Madam,
There was vacancy. I am qualified. I am eligible. I am senior. Those things are required.
Madam, therefore, madam, we have annexed the copy of the vacancy obtained from the RTI, madam. As per the RTI documents, madam.
No. Vacancy, before vacancy, you tell me what is the next promotional post?
Madam, my promotion is the post of headmaster, oblique, madam, the vice principal, oblique, district adult education officer. Madam, recruitment rules I have annexed.
Page. Page. Where is it?
Page 45, 45, 46.
The 11th portion.
It's related portion. 46, madam. 46, madam. 45, it start from district adult education of rules. 45, madam. Page number 45.
Yes, what we have seen.
Madam.
2009.
2009, madam.
This is still in force.
Yes, madam. It is in force.
Then what is the,
Madam,
how is it to be filled up?
madam, madam, how this has to be filled out is at page number 47. Sorry, madam, I am feeling cold, madam, therefore I am not in the position. I am feeling cold, madam, because
You're feeling cold.
madam.
Just take the AC. Is it too cold?
Anyway, madam, madam, page number 47, the relevant there are the lordship see the mode of promotion, madam. It's 100% by transfer of the posting from the senior junior teacher of department possessing degree in bachelor's of education from the recognized institution. And the next post is madam, by transfer of the postings of the from senior most junior teacher, EGT madam, earlier junior teacher madam, is now redesignated age, then graduate teacher. Page number 47.
So how do you read this schedule? It's, how do you read this?
Madam, this is method of recruitment rules 4, madam. 47, 45, madam, again. The method of recruitment.
No, that is there. Name of post, number of post, classification, scale of pay, whether selection or non-selection.
Of that is given is column number 1 and column number of posts, name of post, number of posts, classification, scale of pay, madam, page number 45. And whether selection post of the non-selection post or the non-selection post be given. This is the matter, the as per the
Like, says 100% by transfer.
G. Yes.
Posting. Yes. Then where is the scope of promotion?
Madam, it is from the serving senior most junior teacher. Now, from the seniority list of serving junior teacher, now DGT has to be promoted to the post of madam next higher post.
No. Column number 11. Fine. It already says 100%.
Yes, 100% promotion.
It is 100% promotion.
Transfer.
Not promotion. 100% transfer.
Yes, madam, not promotions. Transfer.
So no percentage is left for promotion by seniority. 100% already taken away for by transfer and posting.
The transfer will be from the only, even if it is transferred, it's only from the list of the serving senior most junior teacher.
No, that is not the thing, what I'm saying. If it's 100%, there is no scope for promotion for anybody. It has to be filled up by way of transfer or posting.
Yes, no, madam.
Your case is not for transfer. Your case is not for posting. Your case is for promotion.
Promotion, madam.
Because of your seniority.
Madam, it is.
There's no percentage reserved for you.
Lordship.
Already 100% is reserved for that.
Madam.
So you have to tell us the rules.
Madam, the rules, of course, specifically, there's not been mentioned, madam. The persons who have been picked up to the next.
So once you say 100%, your 100%, what can you say?
Madam, if
all the posts, 100% means all the posts.
Yes,
are reserved for transfer or posting.
Now, my lord, the private respondent, exactly, private respondent, my lord, whom they had picked up, is, my lord, also was serving a junior teacher, my lord.
That's wrong. That is illegal, but we cannot challenge that.
My lord, here we are challenging the impugn order by
because both of you are saying.
My lord, if lordship perused once, madam, is clearly mentioned, may I take your lordship to the page number 40.
So what is there to be what is there remain to be seen? You have shown me the relevant rules.
And they are saying that
2009 rules.
Yes.
This is for the promotion of the post of district adult education officer. How can a person be recruited? It says 100% by transfer and posting.
And even in the name is transfer and posting, madam. However, madam, something, madam, beyond that, madam, promotion. Of course, promotion word is not used, madam. Madam, after all, from whom this appointment has to be and the transfer and posting has to be done is from the only, madam, the list of this serving.
There is something wrong with the rules,
madam.
See, normally what legally is provided is the 100% by transfer and posting.
Yes.
And there might be a situation wherein there is nobody qualified to be transferred or posted. Then there should be a clause that says that failing which by promotion from so and so having this much years of experience.
Madam, this is the rules only by
That
which
is not there.
Madam, this is the rules basing on which matter that they are giving promotions to the matter my junior colleagues.
Correct. So that is illegal.
Yes, therefore, matter we are basically challenging.
So if it's illegal, you not also claim for illegal promotion.
Negative.
Negative equality. Everybody is being promoted.
Yeah.
I also should be promoted. You can say that.
Therefore, matter
But the rule speaks otherwise.
therefore, matter we are increasing their
So you this rule, you challenge the rule saying that this is really in violation of my opportunity, prospect of promotion.
just for a moment, matter may I take your lordship to the page number 40, by which matter the other my colleague junior has been matter posted matter the promoted.
So you cannot draw your parity with others negative.
Matter.
So Tagu, what is this? What do you understand by this?
Matter
It says method of recruitment. Again, other column 12 says in case recruitment by promotion. Another choice is given.
100% by transfer posting.
Doesn't say failing which
Matter that
failing which one will be post one will be okay. Now I got it. You have to tell me that. See, it also again says transfer. PGT or PGT? PGT is equivalent to district medical education officer.
no matter it is Peter post.
It's a Peter post.
Yeah.
So it has to be filled up by way of transfer and post.
Exactly. But that matter. Let's say seniority that must be there.
Now some things again now things are a bit different now. 100% by transfer posting from so and so. Then by transfer and posting from senior most relative. Now, of course, now what would be the criteria? First of all, we go for column 11. If there is nobody, then we go to column 12. Is it like that?
Yes, we are claiming under block them.
But if there is somebody from column 11, will not get charged.
Of course, matter keep hearing. This is the matter my case. And my juniors matter how seniority is. Matter in the department.
Seniority is.
Matter in the department, matter age of now, they are not preparing the seniority.
Then how do you know that you are senior?
Matter from the appointment, date of appointment order.
But that is not the thing. Date of
From the date
appointment-
of appointment order. matter.
Date of appointment may be the criteria, but it is not always the criteria. It can be something else.
Seniority is to be as in the recruitment routine, as clearly mentions that matter from the senior matter. I am senior at least matter. When it not matter, department is not maintaining the matter the seniority list matter. From the date of appointment matter, from the date of birth even also matter. I am at least senior to them. That is the whole thing. And seniority position is also
What department is this?
education department. Matter in the education department.
Education department.
And those seniority lists are being prepared by the department as of now. They are keep on appointing from to anybody, by we can. It is fair to make some sense since my brother is representing the education department. There is no even seniority list.
So if there is no seniority list, how can you make a claim that you are
By at least by from the appointment order, we can reflect, we can demonstrate at least I am the senior Prior to them, I have been appointed in the department. I am the first person to enter in the department.
The rules itself says senior most.
Yes.
So find out the senior most, one has to draw seniority. Before drawing the seniority list, one has to draw the provisional list.
Provision.
Then final.
In that case, the lordship, my reference submission. If the reasonable code issued the directions to the departments, the is come with the provisional seniority list, at least that could have been
That your prayer.
of course, that is not
That is not your prayer.
yes. However,
Why should we go everywhere?
by the just exercising the power under 226.
No, no. You are also to be.
That will be clarified by the
Vigilant
department.
with your case also.
That will be clarified by the
Vigilant with your
department.
case. Where is your representation? Saying that please fix seniority list so that I can also be considered for.
Matlab fixing, matlab the making that the barrier in the department will be again another the burdensome work for them to fix this.
Make the background. You cannot say that I'm senior.
It will
But
be
by age,
it will be
by appointment order, I'm senior.
it will be best answered by the department. How seniority is not being fixed. At least I am senior to them. Why I should be super senior. That is the barrier. If you don't maintain, if department don't maintain anything, any seniority list, at least
See, you are supposed to satisfy the code. Then only notice the code. Notice doesn't go like that for the mayor asking.
true.
Tomorrow you find two documents that issue notice. But blindly will issue notice.
No, madam. Definitely, madam. But my lord, I am demonstrating your lordship, madam, satisfying your
What's the
lordship.
department thing? What is the code doing? What kind of notice is being?
Now, my lord,
They will say that.
if such is the position, my lord, if lordship see the appointment order of the private respondents, man. Private respondents, man.
Have you made a representation?
Yes, ma'am.
When was that?
Annexure 1, madam.
Next year what?
I'm sorry. Annexure. Annexure 5, madam. Page number 33, 34. Detail the representation was made before the concern of the authorities, madam.
So we sent you.
Yes, ma'am.
We have 3 petitioners, not 3 persons.
But 3, madam, out of 3, madam, we are before your lordship is win number 2. On 7, 8, madam, 2025, madam, we have clearly demonstrated everything, madam. Date of appointment, date of madam, the event, promotion given to the other respondent. Now vacancy position is also shown at serial number 3, madam.
Now, whether joint representation is permissible.
Since we are under zone of consideration, we have made
What does the say?
same cause of action almost.
No, same cause of action, you may file writ petition. But at representation before the authority,
However, madam, we made
you're not an association. You're not a some district.
the thing is we comes under the zone of consideration. Madam. It altogether 3 persons are qualified for the promotions to the next higher. That is the only thing. Madam, regarding this the appointment, madam, there should be as per rule, madam, there should be interstate seniority. I believe, madam, the department is working on it, madam, because some your teacher, madam, now DGT, madam, some of them were appointed in years 90s, 80s, still there, madam, working as a DGT. That aspect of matter, to streamline, madam, interstate seniority has to be there. I believe, madam, they are working on it. That point of madam, at this moment, madam, we cannot say the petitioner is senior most. The rule said the senior most. Irregularity, madam, it appears that irregularity has been committed while appointing here and there, madam. So that is not as per the rules. So for grievances of the petitioner is also not reflected.
But from where you're saying that they're working on the senior.
Madam, it is not here, madam. I believe, madam, because last time I had happened to talk with the authority, they said that but as of now, madam, the status I cannot say, but I believe, madam. Madam, admittedly, there are numbers of the senior who are even not able to getting chance to be promoted to the next higher post. It is happening in the Department of Education, madam. It is impaired to make submission.
Why, for the last 20 years, you were sitting tight. should have given a representation. Where is the seniority list? Please bring this seniority list. Otherwise, 2009 rules says that will be senior most to be promoted. Now, there can be 6, 7, 8 people claiming to be the senior most. There will be more dispute.
Yes. So if once department brings the common seniority list, everything will be clear. And vacancy position, we have already seen.
Who according to have been promoted who are junior.
Private respondents, all private respondents.
Oh, you have made private respondents also.
Yes, ma'am.
Where are they?
Page number 32 is the impugn appointment order by which superseding me.
So your name is shown in the thing,
Madam.
the representation. No.
Yes, madam. Shown in column number, box number 2. It is seen, madam.
Go on.
Reflected, clearly reflected. If madam, lordship again come to page number 33 of my representation.
Yes. What are the names? Which are the names?
Names, madam. These are the names.
Go on.
Serial number 4, serial number 3, serial number 4, serial number 6 and 7.
4, 6, 7.
And 4, 3, 4, 6 and 7. So date of appointment, date of madam joining a junior teacher, madam. BTT. Serial number 4, 2008, 2008, 2015, 2015, and 2017. Whereas my senior, my date of appointment is serial just below. Petitioner number 1, 2004. Petitioner number 2, 2008. And vacancy position, madam, serial number 3. On promotion of these 3 officers.
The first chart pertains to what? Your juniors.
Yes,
And where are the petitioners?
second circle. Just below. Same paragraph 2.
Yes. Who are they?
They are the petitioner, madam. Serial number.
Name. Tania.
Yes, petitioner
This
number
is
1.
P1.
Yeah.
Then number 2.
P number 2. Madam, the serial number 3 is the P number. Petitioner number 2.
This is 2008.
Yes, madam.
Here.
Date of appointment is madam compared to the date of appointment.
See. Number 2.
It is 25 March 2028, madam. And whereas the other junior March, it is 28, 24, madam.
Respondent number 7 joined on 24th. Before you.
Yes. No, madam. It is, yes.
24th.
24.
1 day before.
One day before. Private response 6, madam. 1 year.
The current council submit that as per the
Page number 45.
as per the district adult education officer. 2009. The senior most trained graduate teacher is eligible. The most I think one of the senior most trained graduate teachers have not been considered for promotion. Instead, the private respondents were clear to them. And it was from the London Council subject that the presentation was submitted by the commissioner education. There are posts like that, commissioner education.
Madam, yes. Commissioner,
Not even a party.
Commissioner Education is a party.
Number, respondent number
One.
commissioner. Education. Or segregation policy. So, what is any representation from? Therefore, I have to go respond every day. This day.
Standing count for education. Eight. Keep them.
Item number 2.
Challenging the impugned standard summary report 039/2025. The factual metrics, before I indulge my lord to the annexures, is that on 3/7/2025, NIT was plotted by the executive engineer, SAPA PWD division, for construction of road from Sivibo to Nera via Lamio, Sareva village in East Tamil district for 24 kilometers with an estimated cost of 14 crores 63 lakhs. So thereafter, what had happened on 18/7/2025, my lord will kindly come to page 1111. 111. My lord, we'll see, this is the annexure form, my lord, the technical beat evaluation, there is standard summary reports, my lord. It was uploaded on 31st July 2025 at 1:45 a.m. Now, my lord, we'll see I stands at serial number 3 in the second box, my lord. First, my lord will find Lofa Construction Agency. In fifth row, my lord will see status admitted pre-qualification technical bid. Now, second is Hills Engineering. Then Hill Engineering, my lord, before I proceed further, the Hill Engineering, the proprietor is the wife of the local legislator. I have made a categorical statement there. Local legislator of that particular constituency. So now the serial number 3, my lord. Here I stand, the Sports India Construction Company, my lord. I was technically admitted. Fortunately, my lord, beyond the stretch of imagination, my lord, kindly come to page 113, my lord. We'll see on the top, on the right, the word, the figure 113, just below date, 3rd September 2025, 6:23 p.m. Now, my lord, here what had happened is, kindly see the second box again. I stands as serial number 3. My technical beats stands rejected below. And no reasons, my lord, has been assigned. My lord, kindly come to paragraph 8, where I made the categorical statement of my read petition. Non-responsive. Yes. It's a non-responsive. Just for by convention, such kind of situation, somebody is not found to be responsible, non-responsive, and these are the I suppose do it like that. If bound, they are bound. They are bound. If my lord has this para 8 of my petition, that the petitioner begs to state that after a lapse of 1 month and 3 days from the date of technical evaluation being published on 31/7/2025, the executive engineer PWD Sapa division abruptly issued the impugned tender summary report on 3/9/2025 at 6:23 p.m., wherein the petitioner's technical bid was declared as non-responsive on 2/9. My lord will mark this on 2/9/2025 without assigning any reasons or disclosing the specific ground for such rejections. My lord will recall this Tata Cellular paragraph 94, Jagdish Mandal paragraph 30 is also there. Now, without assigning any reasons or disclosing the specific grounds for such rejections, the rejection being unreasoned and non-speaking in nature is arbitrary and violative of the principle of nature. Furthermore, it is pertinent to note that the technical bids of the private respondents were accepted on 3/9/2025 at 3:30 p.m. without transparency or due explanation for differential treatment accorded to the petitioner. It's a categorical statement I make. Now, my lord, I request my lord come to page 114 again. The order was passed. Now, my lord has seen on 2nd September 2025, the order was passed and it was uploaded on 3rd September at 6:23 p.m. So there was no occasions that the impugned tender rejection was communicated to me, or where I can avail my alternative remedy even for the filing representations. Now, my lord, kindly see the colorable exercise which they have done arbitrarily. My lord will find at page 114. Office order. This office order is constituting the financial bid. Financial bid.
क्या बोल रहा था?
So, my lord will see. Kindly come to page 50, my lord. That is instruction to the bidders. Not reach the financial stage. Yes. Technical stage of the event. Yes. No, no. Technically, I was qualified. Technically, but my financial bid was not taken on board. That's why paragraph 8 minute I have described. Page 111. Yes. Admitted, three qualified. All three of us. This is pre-qualification. Kindly, you are qualified for technical. Yes. Then the next stage was technical. Next stage, pre-qualified, pre-bid was already done. You are qualified. All three forms were qualified, and on 2nd September 2025, the respondent authorities issues the impugned order stating inter alia that you have been found technically non-responsive. And on 3rd, they have conducted the financial bid opening. So, tender summary report is of 3rd September. Correct. Second. No, on the 2nd, it was passed on 2nd and published on 3rd, on the day of meeting. And then, my lord, my younger says at page 115, my younger says I should refer to page 115. Well, kindly see date Milord. Annexure 6 series Milord, page 115, 029/2025. Now there what happens is on this day, Milord, they have constituted the opening of the financial bid also. And on the same day, my technical bid was rejected as non-responsive. Concept is. Okay, okay. Milord, so the disqualification happened on second. Second. Then on second itself, they informed the other two companies. Yes. The other two tenders that they are, for the bid has been found to be responsive. No, but others were done on 3 p.m. On September 3rd. Kindly flip back to page 113. At what stage you were rejected? Technical bid. According to them. So all three qualified. Technical, on second you were rejected. Correct. And on second they informed the other two, saying that on third opening of the. Correct, Miller. And Miller, this is exactly run contrary to ITB 2.246. Kindly come to page 50. The tender opening committee board shall prepare minutes of the bid opening, including the information disclosed to those present in accordance with sub clause 2.41. Meaning thereby, when I was qualified in the pre-technical bid or the technical bid, they are bound to draw a minutes of that proceedings by the board. And accordingly, it ought to have been handed over to us. So which they have not done. As my lord has prophesied seen from the order which they have passed at page 113, Lord. 247, Lord, down below. Minutes of the bid evaluation by tender evaluation committee, board shall be issued by the employer accepting authority. Now, my lord, why I say is the second point, which they have not done, the 2.24.8 also, my lord, because on second you pass the impugned technical rejection order, and on third, and there you have not given me any opportunity, my lord, can see any complaints, representations, or allegation by technically non-responsive bidders about the evaluation process, including the manner in which the bidder has been rejected technically, will not be entertained by employer, nor the employer has liability towards the rejected bidder in any course. Now, my lord, law is well settled. By administrative order or any terms and conditions cannot override the objective of Article 14, right to equality. So this, from a side to my mind, is a fit case for interference. And my simple prayer is also, I am not even praying that entire tender process should be set aside. What I am praying at the moment is kindly take on board my financial bid along with the two other bidders. And so far, my lord, even after opening of the financial bid, work has not been awarded, my lord. We are very clear paragraph. And on this particular proposition of law, one in one read petition, my lord, has passed an order on the similarly situated case. Because here no reason has been assigned to us for why my technical bid has been rejected. WPC 341/21. Bid has already been open. Open, my lord, no work has been awarded. Nobody has been selected. That I don't know, because I cannot, since I am not at the stage of opening financial bid, my lord, so I can't have that. That is my predicament, my lord. No, but the financial bid is open. They have made assessment, but don't know the result. Don't know the results. But my lord, rejecting my technical bid, they ought to assign the reasons. They have not assigned. And on that proposition of law, my lord has interfered in one matter. By order dated 15/11/2025. See, you want me to say that as a frequency 2.24.66. Correct. Tender opening committee votes and frequent minutes of the bid opening including provision. Wait. Correct, but the second line, my lord, will kindly hold on in the second line. The authority will subsequently examine and evaluate the bid in accordance with the provision of section 2.7 of the Act. Now that means on the day of opening, they have to evaluate the bid itself.
My lord, the petitioner claim is that technically he was qualified. But let us re-examine whether actually technically qualified or not. It's subject to the correction from the other side.
One, three.
First, let us see 11111. Triple one is. Top state tender summary report. And the second column says bid list. Bid list are the documents. And status, if you lordship see status, all three parks have been admitted. Admitted pre or technical. Pre-qualification or technical. Right now, all are admitted. So meaning thereby that documents for technical evaluation was admitted. It does not say technically all are qualified. All are only qualified for technical evaluation. Why I am saying I'll stand with that. You Lordship may kindly come to page 113 and 113. Your Lordship got it, Madam?
Now it says rejected technical.
Not only that, Madam. Number one, Madam, your Lordship may kindly see. Bid list. Down below column, Madam. Number one, technical bid opening summary. Your Lordship got it, Madam? Yes. Technical bid opening summary, wherein all three qualified for technical evaluation. Second column comes, Madam. This is the technical evaluation summary. Let's make the difference.
So how to say all of them qualified?
Lordship come back to triple one page, Madam.
No, this 113.
Yes, no.
No, 113, 111, it's okay.
313 is replaced. There are three, my lord, stages. Number one is technical bid opening summary, wherein my lord, if you Lordship compare the 111 page, my lord, all they qualified, no issue. No issue. Now question comes from the second stage.
Yeah.
Technical evaluation summary. Herein, my lord, the petitioner tells.
No technical.
Yes, technical.
But you showed me this technical bid opening summary. Say, segment only once more. Follow.
Number one, first.
This impugn rejection order, just without interrupting to learn a resale AG, kindly come to, if my lord is on B to 113, then after rejection of my bid, my lord will kindly come to technical bid opening summary. So there, my lord will find technical summary, minutes of meeting, updated, so 18 July. So therefore, my lord, Prabhupasai, it goes to show that they have already done the evaluation on this day.
That is wrong. No, no technical evaluation. I'm sorry, madam. No, madam. No, madam. Then when you say, madam, two, madam, see the dates, madam. Lordship may kindly note the upload date, madam. I do Lordship got, madam. Technical bid opening summary was uploaded on 18 July. A technical evaluation summary was uploaded on, madam, 2nd September. Now, how you can say, my lord, in my lord, the technical bid opening, my lord, we have, my lord, already evaluated the document. It is a wrong shot. Another point. Now, my lord, the petitioner says, my lord, it was only uploaded on 3rd September 2025. That is not correct, my lord. The lordship says, my lord, serial number 3, my lord, this is the petition of my lord. The lordship says the extreme right, my lord. Status updated on 2nd September 2025. Time is given, my lord.
6:30.
No. 3:24 p.m.
Okay.
Right. So, my lord, this estimate is not correct that it was uploaded on 3rd. I'm sorry, it was uploaded on the very day itself.
No, but only in respect of 2 firms.
No. Forget about the others. Let us
Mine
focus,
was-
let
mine
us
was-
focus on the my lord, petitioners.
My lord, mine was done on 2nd September.
Correct.
We already.
No, you said that it was uploaded on 3rd. That's so, my lord. So, now, my lord, coming to my lord, this interim order, my lord.
Yeah, what is it?
Sorry, my lord, this constitution of board, my lord. This is 114, my lord. There is no dispute, my lord. It was constituted on 2nd, my lord. The day he was informed, my lord, or uploaded. And the,
What is it for finance?
yes, my lord, for open of finance. It was opened on, my lord, 3rd September, my lord, at 2 p.m. Today is, my lord, 9. It's more than a week, my lord. Now, without taking instruction from the department, my lord, I cannot say, even the petitioner cannot say, my lord, whether, my lord, LOA has been issued or not.
Because approval today.
No, it's more than a week. It was
My
decided on,
lord,
it was decided on, my lord, 3rd, my lord. Today is 9. It's more than a week. So, my lord, you lordship may kindly allow me to take the instruction, my lord, whether, my lord, the process has been completed or not, my lord, whether LOA has been issued to anybody else or not. Or so far, reason is concerned, my lord, yes, my lord, I can obtain the reason, my lord. Why, my lord, which technical bid has been rejected. The lordship has rightly said, there is no any, my lord, even the bids, my lord, as bidding, my lord, where it says, my lord, you have to give detail of the rejection. Only, my lord, clauses is enough, my lord. Under this clause, your technical bid has been rejected. But here, my lord, that part may not be, but I can obtain from the department, my lord. There must be a reason, my lord, obviously, for rejecting any technical, my lord, document. Yeah,
My lord, just,
day after tomorrow or Friday, my lord, anything.
may I request my lord, kindly indulge the case 115 again. I'll establish my case for stay.
On what?
Fine. My lord, this order was issued on 2/9/2025. That is giving intimation to Law Park Construction Agency and Hills Engineering. Now, but then kindly come to page 113. If my lord see the bid list, or last column, the status updated 3 September 2025, 3:30. Without evaluation, without even admitted below, kindly see. On 3rd, you have admitted, and second, you passes this order. Some of us, I will kindly interfere with this, or will make an observation also. Pendency of the writ petition shall not be a bar on the responding authority to take on board my financial bid.
My lord, I will be not agreeing to that, my lord. Why I'm saying, my lord? Now, my lord, my friend is happy on, my lord. The status uploaded, my lord. The 3rd September, my lord, no one is disputing, my lord. Right. What is more important now, when it was communicated to you or some sort of information was given to you? 2nd September, my lord, that no one can dispute, my lord. Forget about the others, my lord, who qualified. The petitioner has to state his own thing, my lord.
My lord, additionally, he is done with, I relying on this, my lord, this particular judgment rendered by lordship on the order. Because, per se, my lord, okay, I concede all your grounds which you have argued, but then you are bound to give the reasons, my lord. And this court, by what dated, my lord, I have one copy, I have this passing, was on date of hearing and judgment. Number 341/22. But I read the operating paragraph. My lord. Well, prima facie, it is a disclosure, my lord. On 2nd, you reject by tender. 3rd, you opens the financial bid. Then I have my protection under the ITBP itself, 2.246 to 2.247, 2.248. You cannot arbitrarily act. My lord. Yes. 3rd, they have opened the financial bid. And the constitution of financial bid committee was constituted on 2nd, or on 3rd, and then without opening the bid, my lord. Page 113 and 115 is very clear.
2nd, my lord, 2nd, not on 3rd, my lord. 3rd was opening of financial bid. No.
Therefore, my lord, whatever the reason has not been assigned. But no further proceedings. My lord, I used to be very honest before the court and with other side also, my lord. I know how things are done in such kind of matters, my lord. So therefore, my lord, my respectful submission, my lord. My respectful submission, my lord. This honorable court has rendered this, unless if you have laid the law, unless you don't assign the reasons, my lord, for rejections, you cannot proceed with the tender paper. That is this, my only submissions, my lord. I leave it at the. Show me a case where it the tender rejected. Detailed reason is given. My lord, that these are the reasons why. Correct, my lord. In the PMGSS scheme, which my lord have also dealt with several cases here, where I have argued and the learned additional AG also appeared. The moment, my lord, this morning also in this item number 4 in the division bench, my lord has seen the technical beats minute. There they give the reasons that these are the clauses you are not qualified, therefore you are rejected. But here is a case, my lord, you have not given that clause also, any clause, where I have not qualified technically. But they say it's not responsive. Non-responsive, my lord, at least something, my lord is kindly aware of the various precedent in Katina of decisions by this court, and Honorable Apex Court also says that any administrative decision must be impregnated with the reasons with rational nexus. So unless, therefore, my lord, paragraph 90, yes.
Other side, my lord, when you say, my lord, Article 14, my lord, is there any discrimination method to my lord petition by imposing that? Now, just the another, my lord, negotiate to see, my lord, overwhelming party intent. Now, here is the case, my lord. One is public interest, one is personal or private interest.
No, my lord, any action which is arbitrarily.
Now, so far, my lord, reason is not given, my lord. Definitely, my lord, I'll take the instruction. The lordship finds, my lord, there is no reason or assigned to, my lord, the petitioner. But reason is, my lord, not bona fide. Then your lordship can pass. Friday, my lord.
Friday will be too late. Friday will
You are
be
only
too late.
late for 8 days, my lord. It was open on 3rd.
No,
We are on
in the
more than 1 week.
you don't finalize other. Yeah, that observation is Not finalized, people already finalized. Correct. Then, but you produce the reasons what has been done.
Correct.
The reports.
My lord, no observation will be made, my lord.
No.
Make sure, my lord. Make sure, my lord. If not finalized, my lord.
Time Moya.
Time, my lord.
And Sareva village in East Pameng district. Packet 24 kilometers, it is packet phase 1. You get this in phase 1. My lord can take small help of my synopsis. I don't even detail that. Assisting. We'll have to skip it for. I don't mind, but if I'm here, everyone will have to be here. This is the problem. I'll delay everybody.
Well, especially that the tender matter. My brother wanted to adjourn, my lord. Tender number 19, my lord.
Yes.
Can it be again listed tomorrow, my lord? So,
Right.
yeah, so, because of interim order.
It's considered by the private. By
Correct.
already done.
But not to finalize the tender, my lord. It is the only problem.
What happened? I have to prevent him from in the by the gathering of the check and the leaving the office for the whole video.
That's why, my lord, I made a prayer, my lord. little bit of modification of that interim order. That will procedurally letter process, but we not finalized.
This can be done.
I did not issue the order. No, my lord, I have the objection. Similar, but when 2 weeks, my lord, I have to make objection. But since
When it come up, remaining items which are not taken up today, let come up. Pilot 14, 20, and 21. I did check up. Why is this for order? And what about that other item? Why is that 14? We have already filed. That's, yeah, you'll be appearing instead of Mr. B. Yes. Conducting counsel for the arguments that the rural development department. The B. is basically this motion. And Mr. N.
item,
14, okay.
my lord, item
21. Can come up on the third? Yes, sir. Okay, similar order for 28. There is an interim order. There is an order passed earlier. This is interim is only on 20 and 21. Yes, right.
my lord, item 3, motion item, madam. I have a my lord, interim prayer there, my lord. If my lord is not taking up the matter, my lord, can it be a fixed item tomorrow, my lord?
I come tomorrow. Meeting item. Possible.
Yes. I think for the, much time because I'm otherwise pressing for an this because I've checked this is a writ of warrant questioning the appointment of the private respondent which has been appointed. He goes the route without any important.
Unless we here see the file and how we have to.
From check the
It can appear online. Okay, remaining matters listen for the data.
I'm sorry, the item number 19, anything of that is not to visualize any other matter.
19.
19.
What interim order?
Interim order not to finalize. Not to finalize.
Okay,
Maybe continue.
please write down due to positive effect, the matter could not be taken up. That's great for this matter. Oh. Interim order.
Enter.